Gonna have to get that worked out later. Procurement. Good morning. I'm Ward 1 Councilmember Nadeau, the Chair of Committee on Public Works and Operations. Today is Wednesday, December 6th. The time is 9:38 a.m. And I am calling to order this hearing held jointly with the Committee on Executive Administration and Labor. In a moment, I'll turn to my co-chair, Councilmember Anita Bonds. The first portion of today's hearing is being held jointly with the Committee on Executive Administration and Labor to consider B25-351, the Sexual Harassment Investigation Integrity Amendment Act of 2023, which was referred to both committees. After that, we'll transition to consider three bills that were referred only to the Committee on Public Works and Operations. I introduced B25-351 on June 28, 2023. In the wake of disturbing allegations by two female district government employees of sexual harassment against the mayor's chief of staff and deputy mayor. What followed was an insufficient investigation of those allegations as perceived by the public and the council. I introduced emergency legislation around the same time, which was unanimously passed by the council, which required an independent review of the internal investigations by the mayor's office of legal counsel to restore trust with employees and taxpayers. More than what was in the report or not in the report, what made the investigation unsatisfactory was the lack of independence of the office conducting the investigation. Even if the investigation was perfect in every aspect, how would we know and trust that? After all, the subject of the investigation was the mayor's associate and confidant. How could the 36,000 employees of the district government trust that investigation was free of internal conflict? And how does that impact an employee's decision in the future about whether to come forward with allegations of sexual harassment when they're not sure their case will be reviewed with integrity? No employee should feel safe in their workplace, unsafe in their workplace. No employee should be subject to sexual harassment, especially by those in positions of authority and influence. No employee should fear retribution or just as bad inaction for coming forward. The Sexual Harassment Investigation Integrity Amendment Act would require that when allegations of sexual harassment are made by executive branch employees in top-level positions of power, those who are appointed by the mayor, those allegations will be investigated by a third party outside of district government. The goal is to minimize the risk of intended or unintended bias and even the perception of it. Recently, the mayor issued an executive order that updated the sexual harassment policies in the executive branch of government. The order provides clear guidelines regarding workplace relationships and definitions of sexual harassment and requires more frequent training. And it also includes provisions like those in the legislation, which we're hearing today, requiring independent investigations when there are allegations against top administration officials. Why then is this legislation still necessary? There are two reasons. First, an executive order can be revoked or updated at any time by the current or a future mayor. This legislation would set practices into law. Second, while I greatly appreciate that the mayor's executive order borrows heavily from my legislation, its provisions apply to a much smaller group of officials in the DC government. People who work for them are more likely to hesitate before bringing allegations, more likely to fear that their claims will be dismissed, more likely to fear negative repercussions for bringing forward claims. The mayor's order applies to cabinet level positions. This legislation would apply to all mayoral appointees, including agency and sub-agency heads, deputy mayors, and those appointed to boards and commissions. Employees must trust that their allegations will be taken seriously and that an investigation will not be influenced by internal or external politics or the appearance of politics or by the power wielded by the person being accused. The public should be able to trust that we're protecting employees, protecting the use of district government assets, and that government offices are focused on and capable of doing the work they're assigned in an environment and culture that supports that work. I look forward to hearing from our public and government witnesses on this bill today. And I'll now turn to Councilmember Anita Bonds, my co-chair, for opening remarks. Thank you.
Thank you very much, Chairwoman Nadeau. Good morning, everyone, and thank you very much for being here. And my thanks to Chairwoman Nadeau for holding this joint roundtable today. I'm pleased to co-chair the joint hearing. Specifically, to talk about Bill 25-351 Sexual Harassment Investigation Integrity Amendment Act of 2023, because we all know that sexual harassment is a very serious concern. Let me start by telling the listeners what I have done regarding sexual harassment among DC government personnel in my capacity as chairperson of the Committee on Executive Administration and Labor. Firstly, I held a separate roundtable on November 14th, 2023 to examine the Mayor's Office of Legal Counsel, the Department of Human Resources, the Office of Human Rights, DC Public Library, and the Department of Public Works, and the Office of Risk Management on the implementation and processes of the updated Mayor's Order of 23-131. Secondly, I have continued to work on developing legislation to address this serious issue. In fact, this week, I circulated a new piece of legislation to my colleagues titled Straightforward Approach for Fundamental Equity in the Workplace, Safe Workplace Act of 2023 to address this important issue. The new Safe Workplace legislation will be filled and filed for introduction on Friday of this week. Since I began this investigative process over the summer, I sent each district government agency a survey requesting raw data on sexual harassment complaints from FY 2018 to 2023 and held a working group. And so the legislation is the culmination of those activities with a great deal of focus on the contents of the mayor's new order 131 of this year. It also contains some of the provisions that were provided to the committee by the courts, DC court system, as well as a few provisions that are included in the documents that we follow at the council. So the whole idea was to at least attempt to make it as well-rounded as possible. And because it is a piece of legislation, it will find its way into a public hearing. If you recall, the comments that we have received thus far on the legislation have been designed to hear exclusively from the government. But once it becomes a bill and referred to a committee, the hearing will be a public hearing. And so I just want the government, our government, to note that that is the process that we will be following. And I'm looking forward to the outcomes. Of course, my colleagues will be available to ask many questions, perhaps, and hopefully we can ultimately put this matter to rest in our government. We're a good government, a strong government, and we do not need to operate under a cloud. And so today, I am here because I think Councilmember Nadeau's bill that's before us, 25-351, its intention is the engagement of an independent investigation regarding complaints against district government employees in high-ranking positions. And so today I look forward to hearing from the executive. And I'm just very proud to see, as I look out, representation from our government agencies, and a double bit of pride because most of the agencies are in my committee. So with outstanding pride, I'm happy to have you all here and look forward to what you have to share with us. And so with that, Councilwoman Nadeau, turn it back over to you.
Thank you, Madam Co-Chair. All right, just some additional logistics for today. The hearing is being streamed at brianneknadeau.com/live. And to ensure that we have time to hear from all members of the public, witnesses will be asked to stick to their allotted time of 5 minutes for an organizational representative and 3 minutes for all other witnesses. The Zoom format is a webinar, so you will not be able to see anything but the main speaker until you are promoted to your panel. Make sure that you respond to the invitation to be promoted when your name is called, and then you'll have the option to turn on your camera and your microphone. For any technical difficulties, you can send a message through the Zoom to Ariel Ardura, labeled as DC Council Committee on Public Works and Operations. And if you're having trouble gaining access to the Zoom, please email publicworks@dccouncil.gov. So we'll now turn to our public witnesses on Bill 25-351. And today that includes Robert Vincent Branham. Okay, Mr. Branham, when you're ready, you may begin. Thank you.
Thank you.
Uh-oh. Your camera's on, but it's not showing you. Mr. Branham, I just want to make sure you haven't started because we can't hear you. Should we try demoting him and promoting him again? I'm not exactly sure what else to do. Oh, there he is. Looks like he's joining from another device. Great. Okay, so try unmuting and let's see, make sure it doesn't mess with the audio on your other. Well, why don't we demote?
Are you here, Mike? Can you hear me now?
Yeah.
Okay.
There is a little bit of an echo. I think it might be because you're logged in twice. Can you?
I'm trying to mute my laptop so that it won't interfere. Am I clearer now?
Yes, that's better. Thank you very much. You may
Okay.
go ahead when you're ready.
Thank you. Good morning, Chairwoman Nadeau, Chairwoman Barnes, and members of the committee. I am Robert Vincent Branham, former president of the Bloomingdale Civic Association, president emeritus of the DC Federation of Civic Associations, and a former advisory neighborhood commissioner 5C04 and 5C08. I appear before the committees to offer specific testimony in support of Bill B25-0351, Sexual Harassment Investigation Integrity Amendment Act of 2023. The intent of this bill would be to require allegations of sexual harassment made against executive branch employees in positions of power be referred to an independent investigator with experience in investigating sexual harassment allegations. Past and recent reports of inappropriate conduct and behavior by senior executive employees in senior executive positions offer insight into the need for this legislation. While the intent and purpose of the bill are necessary, laudable, and should be approved, I feel the bill needs to be strengthened to include racial and age discrimination. Moreover, there must be specific language in the legislation which does not allow for exemptions of investigation of harassment, discrimination, and retribution claims from district employees with mayoral appointments. In addition, senior executive employees should not be exempt or protected from investigations when there are allegations and filed charges of domestic violence, to include any charges later withdrawn. Yes, all executive appointees serve at the pleasure of the mayor. However, their removal, retention, or confirmation should not be based upon a political interpretation of laws governing all district employees. It is indecent for senior executive level appointees to find hopeful protection because a complainant is a spouse, a domestic partner not employed by the district government, or other exempt employee. It is further indecent for persons nominated for agency directorships requiring council confirmation to get a pass from a public council nomination hearing or an investigation into alleged criminal transgressions and employment discriminatory practices. It is questionable for any senior executive with substantiated alleged pattern of age, employee, race, and sexual discrimination lawsuits reviewed by Governmental Human Resources Agency for directing a hostile work environment and arrested on a complaint of domestic violence will be considered a high candidate for employment or remain in a valued position of public trust. The ultimate question would be, or should be, how real or significant is the high standard for senior executive appointed employees who serve at the pleasure of the mayor. The committees and the full council have a duty and a responsibility to provide oversight, direction, and a clear sense of duty to protect district employees and its residents from abuse at the bidding of zealous and jealous senior executive officials employed by the District of Columbia government. Thank you.
Thank you very much, Mr. Branham. I appreciate your testimony, and some of it goes beyond even what we're trying to do here today, but it's very germane to the work of the committee. So thank you very much. I'm going to turn to my colleague to see if she has any questions, although, Mr. Branham, are you still with us?
Yes.
Okay, go ahead, Councilman.
Thank you very much, Mr. Brennan, for your testimony today. As you know, we are like a lightning rod focused on sexual harassment. The issues that you point out, age and racial discrimination, are also extraordinarily important. And I think you want to have a conversation. I hope you want to have a conversation with the Office of Human Rights as to what needs to be done in that realm. The Office of Human Rights is not in my committee, so I have to remind you of that, although these issues are very concerning across the government. But I am hoping that you will have a conversation with that office. And again, I appreciate you, dear neighbor. Thank you.
Thank you.
Thank you very much, Mr. Branham. Okay, that concludes our testimony from the public. We'll now be joined by our government witnesses here in the chamber. Ask them to make their way to the witness table. Inspector General Daniel Lucas, Director Charles Hall, the District of Columbia Human Resources Department, Rachel Noteware with the Mayor's Office of Legal Counsel. I'll ask you to, before you get comfortable, raise your right hand. Do you swear or affirm under penalty of perjury the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Excellent, thank you. Fantastic. So, assuming you've decided what order you're going in, you may begin your testimony. Thank you.
Good morning, Chairperson Nadeau, Chairperson Bonds, and members of the committees. I am Daniel W. Lucas, Inspector General for the District of Columbia. Thank you for the opportunity to testify today on Bill 25-0351, the Sexual Harassment Investigation Integrity Amendment Act of 2023. Our employees deserve a welcoming work environment, one that is free from harassment and discrimination. I agree with the sponsors of the proposed legislation that we must take allegations of discrimination and sexual harassment seriously and carry out resulting investigations objectively. Before I turn to the bill under consideration, allow me to provide you and members of the public with a brief overview of the Office of Inspector General, or OIG. By law, the purpose of the Office of Inspector General is to independently conduct and supervise audits, inspections, and investigations relating to the programs and operations of district government departments and agencies, including independent agencies. Provide leadership and coordinate and recommend policies for activities designed to promote economy, efficiency, and effectiveness, and to prevent and detect corruption, mismanagement, waste, fraud, and abuse in district government programs and operations, and provide a means for keeping the mayor, council, and district government department and agency heads fully and currently informed about problems and deficiencies relating to the administration of these programs and operations and the necessity for and progress of corrective actions. Now, regarding today's joint hearing, if enacted, Bill 25-0351 would amend the District of Columbia's Human Rights Act of 1977. Specifically, the proposed legislation would modify DC Code Section 2-1403-03, which governs the establishment of procedure for complaints filed against district government. The proposed amendments will provide that, notwithstanding rules promulgated by the mayor in responding to allegations of violations of the Human Rights Act by a district employee, any formal or informal district employee complaints of harassment or other unlawful discriminatory practice against an agency director, mayoral appointee of a subordinate agency, board or commission, or any employee directly reporting to the mayor or city administrator be referred to the OIG for investigation by its independent counsel. The OIG's independent counsel would be required to produce a report of findings regarding the alleged violation. If any violations are found, independent counsel would also assess whether any district government resources were expended during the unlawful acts and whether workplace culture, management procedures, or other broader factors contributed to the unlawful discriminatory practice. The impact of the Sexual Harassment Integrity Act of 2023. Considering the council's intent, the OIG mission, and the proposed requirements found in the bill, I would like to identify 5 specific matters requiring the council's attention. Independent counsel can be expensive. As the committees are aware, emergency and temporary legislation introduced on July 10, 2023 requires the OIG to hire and direct independent counsel to review and investigate matters related to the former deputy mayor for planning and economic development. Based on proposals received from 3 solicitations, we estimated that the cost to retain independent counsel for this one investigation could be up to $600,000. If enacted, Bill 25-0351 will require similar resources for each investigation, each independent investigation. In addition to the costs of hiring and administering a contract with independent counsel, the OIG would need at least 1 full-time equivalent to manage the process and administer the contract. The OIG does not have sufficient FTEs or funding to implement the bill. Second, required referrals would cover more than just sexual harassment complaints. The potential cost becomes compounded by the scope of the referral requirement. Under the bill, the OIG must hire independent counsel to investigate not only sexual harassment claims, but it also must secure independent counsel for any alleged discriminatory practice in employment prohibited by the Human Rights Act. Though the proposed legislation will require the OIG's independent counsel to have experience in confidentiality and sexual harassment law, given the breadth of the coverage, independent counsel will require extensive experience in all aspects of employment discrimination. The council should consider whether referrals to the OIG and subsequent investigations by its independent counsel should be more narrowly focused on sexual harassment allegations. Third, the bill provides the OIG with no discretion. Every complaint must be referred to independent counsel. The proposed legislation also provides that investigations of a formal or informal complaint of harassment shall be referred to the Inspector General. Thereafter, the Inspector General shall hire and retain independent counsel to conduct prompt investigations into any complaint referred to OIG. What is unclear is who it is that determines whether an investigation is needed. At the very least, the OIG needs discretion to evaluate formal and informal complaints received before expending finite resources to engage the services of independent counsel. Fourth, the bill provides little opportunity for quick, informal resolutions. The Office of Human Rights, on behalf of the mayor, has established rules of procedure for investigation, conciliation, and hearing of administrative complaints filed against district government agencies, officials, and employees alleging violations of the District's Human Rights Act pursuant to DC Code Section 2-1403.03. OHR's rules concerning complaints of discrimination in the district government are found in Title IV of the DC Municipal Regulations. If enacted, the proposed amendments would insert the OIG's independent counsel into the district's current regulatory process, specifically concerning the filing and presentation of complaints and investigations, by requiring the investigation of any formal or informal complaint against specific district employees. This would bypass any opportunity for these matters to be addressed through pre-complaint processing. Forego the complainant's decision to file and present a formal complaint or voluntarily withdraw a complaint, exclude the OIG's ability to evaluate the veracity of the complaint prior to initiating an investigation, and bypass the district's statutory requirement to mediate a complaint before investigating. The council should consider whether an immediate investigation following a complaint referral is the most prudent course of action, without considering other administrative remedies available to and required of complainants. It is unclear how the bill will comport with current procedures governing the adjudication process for complaints of discrimination in the district government. For example, the DCMR specifies that upon completion of an investigation, OHR is responsible for reviewing the investigative findings and making a probable cause determination, or no probable cause determination or substitute determination. Both the complainant and respondent are afforded the ability to request reconsiderations of OHR's determinations. Further, any subsequent reconsideration by OHR in hearing before an independent hearing examiner could require additional investigative work. The bill's resulting bifurcation between complaint and investigative process could inadvertently affect individuals' due process rights and trigger an increase in judicial reviews. Finally, overlap and duplication of current complaint processes. Notwithstanding the regulatory processes previously discussed, DC Code Section 2-1403 requires an agency's immediate and independent action regarding any alleged violation of the district's Human Rights Act that it receives. As the council is aware, the recently updated mayor's order, updated district government sexual harassment policy guidance and procedures, requires allegations of sexual harassment against the mayor, city administrator, mayor's chief of staff, mayor's senior advisor, director of the MOC, any deputy mayor, or any official who directly reports to the mayor to be referred to the OIG. Following with the referral, the OIG will determine if the allegation is credible and refer the matter for independent investigation. Given the updated mayor's order is non-exclusive in terms of remedies, there could be instances when the OIG's independent counsel will be directed to investigate an alleged violation of the mayor's order and subsequently required to investigate the same complaint in violation of the Human Rights Act. While evidentiary standards differ between an investigation conducted under the mayor's order and the Human Rights Act, the potential for duplicative investigations will result in unnecessary expenditures of district resources. In closing, again, I reiterate our standard goal, our shared goal to provide district employees a workplace that is free from sexual harassment and discrimination. I believe we can work together to further the goals of addressing sexual harassment and discrimination complaints made against high-ranking district officials and appointees, as contemplated by this legislation, while maintaining the independence of the OIG. Notwithstanding the issues I discussed today regarding the proposed legislation, I must remind the council that DC Law 25-0079 requires the OIG's independent counsel to review and make recommendations on sexual harassment complaint and investigation procedures of the district government. As such, I believe it is prudent to wait until these findings are provided to the committees before markup of the bill 25-0351. Thank you for the opportunity to discuss the bill, and I am available to answer your questions.
Thank you so much, Mr. Inspector General. We'll do 10-minute rounds here. Inspector General, how has the agency been paying for implementing the emergency legislation the council recently passed that you mentioned? Okay, thank you. And how much funding do you anticipate needing to carry out that investigation? And what are the challenges you're currently encountering with the solicitation process? And how do you think that can inform our approach for the permanent bill? Just so they can hear you at home.
You're right.
You speak very clearly, but thank you.
We've gone through 3 solicitations. The first 2 were challenged by the initial funds we allocated, which was $450,000. And the second issue was related to small business subcontracting requirements. As you know, we increased the budget to $600,000, and we got a waiver for the small business subcontracting requirement. We're now in the middle of the 3rd solicitation.
Okay, so to me, it sounds like considerations for the permanent bill would include adequate budget and then also an understanding of how we might need to navigate the procurement laws.
Yes.
Anything else?
No, I think that's it.
Okay. Anything else, any other challenges you might anticipate as more of these types of referrals would come to OIG?
I think that the biggest challenges for us, and this is not knowing the scope of referrals that may come our way.
Right.
It could be 5, it could be 100.
Right.
We don't know what that number is. And until we have an idea of what the potential scope can be, we can't really budget, for this requirement or dedicate full-time resources to manage the process.
That makes sense. It should be said, I think, that this is sort of, the investigation is when things have already gone wrong, right? And part of updating the policy, I know for the mayor's executive order, for example, is to prevent it in the first place, right? And I'm hopeful that with a stronger, more clear policy in place, it speaks to a number of different concerns that weren't currently in the order. We never even have to use the bill, but it's hard to know.
Right.
Yeah. So, in your opinion, is OIG's independence important for investigations into sexual harassment by people in positions of power, such as those contemplated in the bill?
So that's an interesting question. As you know, we are here to be the independent and objective fact finders for the district. Independence and objectivity is always important, no matter who's doing the investigation. So when you take this particular process outside of management channels, under the auspices of ensuring independence and objectivity. That's what you get when you turn it over to the OIG.
Got you. Thank you very much. In what way do you see this bill as being similar to the mayor's order, and what way do you see it as different?
It's similar in its goal to have a mechanism in place to address alleged sexual harassment, misconduct, or discrimination by senior officials in the district government. There are some nuances about how and when investigations are to take place. I think one of the biggest differences, and this is something that would have to be addressed, is not giving the OIG any discretion to determine if a matter needs to be investigated. If we were to have to investigate every informal or formal complaint that comes our way, we'd spend the majority of our time and resources dealing with this particular issue.
How would that look if you had the discretion?
Well, we would use the similar discretion that we use in our hotline program.
Okay,
That is to say, not every complaint we receive requires an investigation.
sure.
Not every complaint we receive requires an investigation of the OIG. We have particular processes in place that help us determine if we should embark on an OIG investigation. And if the answer is we shouldn't, we'll make a determination on what should happen. But that's critically important, for us, because as the Inspector General, I would feel it's a waste of, the agency and my team's time to investigate something that we probably would assess doesn't need a formal investigation.
You probably get a lot of complaints to the hotline and of varying orders of magnitude. If OIG had the discretion in this case, how would you assure that sexual harassment allegations sort of rose to the top in terms of their consideration?
So are you talking about a sexual harassment complaint rising to the top of head of other matters or?
Well, I guess maybe I need to know sort of how things get triaged now. But mainly because I'm sure you get complaints that may seem minor, that maybe we haven't passed a special law about. And I think we share the goal of making sure that these allegations are taken seriously. And so I just want to think about how we would ensure that they're not sort of lumped in with other complaints.
Right. So every complaint that comes to us gets the same treatment. It goes through the exact same process. It doesn't matter what it is.
Mhm.
And our goal there is to determine how do we address the issue. Sometimes it's through an OIG investigation. Sometimes it's a referral to an agency or the mayor's office. Sometimes it's training we recommend. There's a lot of avenues of redress that we have when dealing with complaints. And those include referring individuals to other agencies who are better suited to handle a particular issue.
Does your office receive sexual harassment complaints at all now? Have you in the past?
I can't say that we have.
Okay.
If we do, they go through a process where we recommend them to OHR.
To OHR. Okay. All right. You testified that the bill may inadvertently secure independent counsel for any alleged discriminatory claim. That's not what we intended, so let's just get that out there. And we did intend the scope of the bill to be limited only to sexual harassment claims. Are you able to point to the language that you think is triggering that for your analysis? I'm wondering if it's other unlawful discriminatory practice. Is that the one? Okay. Seems like something we could tighten up.
Yeah.
To make sure that we're not going beyond
Right.
scope.
That's why I wanted to bring it to your attention.
Absolutely. Thank you. Can you discuss the importance of transparent investigations that protect victims and don't make them relive their trauma? And what does OIG do to minimize harming victims while ensuring transparency during investigations?
These particular investigations are notably important in that regard. In conducting the investigation, we would obviously have experienced people conducting investigations, that know how to, ask questions, that know how to treat particular victims, that know how to respond should something occur during an interview, to make sure everyone is protected while still eliciting the information we need to get to the bottom of matters. So we, although we haven't done sexual harassment investigations in the past, we are totally aware of those types of needs while we're conducting those investigations.
I have one last question, which is great because I'm almost out of time. When the bill was first introduced, there was some discussion regarding OIG's required disclosure to federal law enforcement if it found criminal conduct had occurred. I'd like to know, what are the steps that should be followed for making that disclosure, and what's that procedure like?
In our enabling legislation, we're required to report to the Attorney General, and that would be the U.S. Attorney's Office, when we suspect there's an alleged criminal misconduct. And that is a conversation between my criminal investigators and the U.S. Attorney's Office.
Okay, and you said, I'm sorry.
And sometimes MPD and the Attorney General, depends on what the nature of the crime
Depends on
is.
what it is because they have different jurisdictions. Okay. Well, thank you very much for your testimony. I'll now turn to my colleague and co-chair, Councilmember Anita Bonds.
Thank you very much, Chairwoman. And thank you, of course, the entire panel for being here with us today. My questions are more around the process that this bill lays out. And that is a process where your office, Mr. Lucas, would in fact be in the business of hiring an independent investigator or investigation to look at these matters. So I'm a little confused. I think we just concluded a discussion about how you would do an investigation and what the parameters are. It's my understanding that the bill is focused on you being more like the agent of the government that would actually find resources that would then mount the investigation. Is that your understanding, or am I missing something here?
That is my understanding, but
Okay.
the OIG would have a role hiring of an independent counsel. That is, we would receive the complaint. And so we would have to make a determination. Well, we should have the latitude to make a determination on if we move forward with an investigation. That would be the OIG's role. And then from there, if we determine that investigation is warranted, we would simply manage the process of the independent counsel conducting the investigation.
So if that were to happen, if that is really the direction we're moving in, we're saying that we would have to add a new objective to your work, because currently your work does not speak to sexual harassment
Correct.
and personnel matters.
Correct.
I just want the public to understand that. That's what we're really talking about this morning. And as such, you are telling us that it would require additional FTEs, at least one. And if the volume of complaints accelerate beyond 1 or 2 or 3, maybe more FTEs.
That's correct.
All right. I just want to make sure that we all understand I know you understand, but I mean, I want the public to understand that may be listening, that that's what we're talking about at this moment. When I think back about the findings that we have received from the operating side of government, and two other complaints we received outside of the operating side of government. We're talking about less than 400 complaints over a 5-year period. And most of the complaints are verbal as opposed to, physical, some, shoulder, leg or something like that. And I mention that because I want the public to understand that we're talking about sexual harassment in general. It's very broad. It's not just an encounter with an individual where there is touching. Um, can you give me some sense of the authorities that you currently have as OIG, your law enforcement authorities? Has there been in situations that you have examined where sexual harassment may have been a part of it, the investigations that you've done? You're always looking at fraud and what have you.
Yeah, I cannot think of any off the top of my head, but generally speaking, whenever we see that particular behavior, it's carved out of any complaint that we receive, and it's referred to OHR or sometimes back to agencies.
All right. I know in your examination of situations of fraud, usually mismanagement of funds, et cetera, within a office environment does involve situations where someone else may know what's going on or suspect what's going on, and there may be or may have been opportunity for bullying or retaliation if I'm doing this. And so I was trying to distinguish whether or not some of that maybe has occurred.
I mean, we get that kind of language in complaints. And unless, the particular behavior is directly related to fraud, waste, abuse, or mismanagement that we're investigating, we typically don't deal with it. We'll turn that over to other entities that are more appropriate.
All right. I just wanted to, have a clear understanding of, the breadth of your work and how you just might run across some of this and whether or not, okay. And so, all right, well, thank you very much. I'd like to, can I talk to the others now or you want me to wait?
Oh, yeah, sure.
All right.
Absolutely. Use your time.
All right,
I just
thank
happened to
you.
Use my first 10 on him.
Okay, thank you very, very much. Mr. Hall, thank you very much for being here. I know you want to talk to us about the mayor's order and some of the outstanding provisions in the new order that are different from the old order of 2017. So if you would put a couple of those on the record, because when we were looking at drafting legislation, we found that there were pieces of information that we think need to be in the public domain so they understand where we are. Please.
Sure. So first, thank you for having us today. We appreciate that. A couple of the things that are new. So of course, there's the update to the definition of sexual harassment. It includes any conduct of a sexual nature that constitutes harassment, which is conduct that is direct or indirect, verbal or nonverbal, that unreasonably alters an individual's terms, conditions, or privileges of employment, or has the purpose or effect of creating an intimidating, hostile, or offensive work environment. Also, what's important to remember is in conjunction with the definition that council passed, quoting the expanded definition of sexual harassment, providing that actions do not need to be severe or pervasive, nor do several incidents need to occur to constitute sexual harassment. The expanded definition means employees are empowered to report even a singular or small incidents. So that is one of the updates. Another update is the prohibition of chain of command relationships. So anyone that is a supervisor and those that they're supervising, those, whether it's direct or indirect, those relationships, dating, sexual, or romantic, are now prohibited. So that is an update to the mayor's order. Another update is that is more clearly outlined in the mayor's order. It was implied in the 2017 mayor's order, is that a employee can utilize any show in any agency. So they're not confined to the show in their agency. Of course, keeping in mind that they are not limited to a show. So they can report to the GC, they can report to their supervisor, the supervisor of the person who committed the offense, and they still have the options of going to OHR, the Equal Employment Opportunity Commission, and of course, there are legal options that they can take as well. And then the mayor's order also more clearly outlines the sexual harassment task force that was again implied in the 2017 order, but now is outlined to say that there are specific persons that will make up this task force, which include the Office of Human Rights, the Mayor's Office of General Counsel, the Department of Human Resources, the Assistant City Administrator, and the Mayor's Office of Legal Counsel. And really what they'll do is they'll focus on reviewing training, employee guidance and policies, and recommending any needed changes. As we know, this is ever evolving. We want to make sure that we stay on top of it.
Thank you very much. I only have 9 seconds. I have to come back for a second round in fairness.
As many rounds as you like. That's what we're here for today. So certainly I can continue with Director Hall. Thank you for joining us. Could you walk me through the agency's process of developing, adopting, and publishing complaint procedures for sexual harassment claims?
Sorry about that.
No problem.
When you speak to the agent, are you talking about the show process?
Well, I'm actually talking about how you went about developing the procedure itself, the sexual harassment policies. Yes. So show. Yes.
Got it. So
Yeah.
yes, so the show process really is a continuation of what was in the 2017 mayor's order.
Okay.
And that process entails an employee having the option to go to their show, which is in the agency. Each agency has a primary and a secondary show, just so that everyone knows. They can go to their agency show or a show in any agency. They would report the matter to the show. That show is going to conduct a investigation. Now, it's important to remember that the investigation is not a legal investigation. So when the show is conducting, it's not a legal matter. They will also make sure that they connect with the GC in the agency, and the GC will inform and alert the MOLC so that there is documentation of this claim. The report, unless there are extenuating circumstances, the report and the investigation would conclude within 60 days. That would then be provided to the GC and the agency director, who would then determine what the appropriate next steps are. Additionally, the MOLC is informed of the outcome, and there in the new mayor's order would be a report on the outcomes of the investigation that would be provided to the employee and the person who was the offender.
Does the MOLC typically weigh in, or would the MOLC weigh in on the outcome?
Can I answer that?
Yes, absolutely.
On behalf of the MOLC? No, we don't weigh in on the outcomes. That we receive the results so that we're apprised of any issues that are happening at the agencies, that we're prepared for any litigation that might occur. But we don't comment on the outcomes of any investigations nor weigh in before the findings are made.
Would you anticipate the MOLC ever needing to advise general counsel and show that something was lacking legally?
If agencies have questions about an investigation or if something was done properly, of course, they're able to reach out for legal advice from the MOLC. Agencies do from time to time, and it's described in the mayor's order, have an insufficient show investigation, and the agency itself can go back to the show and say, we need you to beef up this investigation. We need further investigation in order for us to be able to understand if any claims can be substantiated.
But the buck stops with the agency, more or less.
Correct.
Okay. How is a sexual harassment investigation structured? I guess you kind of just walked through that. Is what you just described, Director Hall, standard template, or does each agency have the ability to use their own format for how they go about this?
Excellent question. So all shows are trained to utilize this format. So of course, there may be intricacies that they need to check in with the GC or the MOLC with, but this is the standard approach that all agencies under the mayor's purview would take.
Okay, and I want to confirm, does every DC agency or office have a dedicated show right now?
Right now, every agency has a primary and a secondary show. Yes.
And every agency that exists has a primary and secondary show?
So those under the mayor's authority.
Okay, right, understood.
Yes.
Anything we think of sort of colloquial as an agency that technically is just an office that has a different structure?
That's not under the mayor's.
Well, for example, this committee oversees the Mayor's Office of Community Affairs. Under that, there's the Office of Veterans Affairs, there's the Office of Latino Affairs. So how do those offices relate to this structure?
Yeah, so I believe those offices fall within EOM, and they would all have a primary and a secondary show.
And that would be the primary and secondary show of EOM, and all of those offices could go to that.
Excellent question. So a smaller agency does have the option to utilize the primary or secondary show in a larger agency. Part of that is to ensure that there is a level of confidentiality. Smaller agencies, you don't have that bandwidth. And so they could utilize a show from a different agency.
Anyone can go to any show.
That's correct.
Right. Okay. Can you say more about the training that the shows receive?
Sure. So it's an annual training that is held in conjunction with the Office of Human Rights and DCHR. It is annual. And so there is literally a training so that they go through everything from, let me give you the specifics so I quote it correctly. They're trained on everything from knowing how to write the report, ensuring that they can collect and weigh the evidence, providing impressions of the credibility of witnesses, corroborating, substantiating, and refuting factual allegations. And so all of that is part of the training that shows primary and secondaries go through.
Thank you. How often is the list of shows posted on your website updated?
Yes, so what we've asked is that when there are changes, it would be updated. So agencies should inform DCHR and OHR of any changes. We have recently updated the listing that is posted on the DCHR website.
Of course, there's always a chance that someone forgets. Is there any sort of reminder that goes out regularly to be sure they're updating them?
Yes.
Okay.
So one of the things that happens is we meet regularly with agency HR personnel, and that is a reminder that we would provide to them.
Very good. So why do we allow DC employees to file sexual harassment complaints in several places?
We want to make sure that persons know that there are avenues available to them outside of the show process. And so of course, they can go to the OHR, they can go to the court system, they can go to the Equal Employment Opportunity Commission. That ensures that employees know that there are avenues that they can take in addition to what is provided to them in the mayor's order. And it's important to note they can all occur at the same time. So they can go to a show and still take any of the other avenues as well.
Okay. Now, on October of this year, the Washington Post reported that it obtained through records requests the collection of MOLC data, which showed all sexual harassment complaints investigated under the mayor's 2017 order. The article was quite disturbing with respect to how inconsistent the application of the mayor's sexual harassment policy has been depending on the agency. In one case, 11 women accused a Department of Health employee of inappropriate touching and masturbation by placing his hands inside her pants during face-to-face meetings. The allegations were only substantiated in part. In another case, the Department of Human Services found an employee slapped a woman's behind while she was talking to a colleague, but the agency concluded it was not a violation of the mayor's sexual harassment policy. What procedure does DCHR have in place to prevent retaliation after an agency makes an unsubstantiated finding for a sexual harassment complaint?
So there is part of the mayor's order does speak to retaliation and ensures that the employee is aware that there is a process. They can follow up, of course, with persons within their agency. They can reach out to OHR. They could also reach out to DCHR for additional support.
So what would that process be then? If, if, let's say I filed a complaint, it wasn't substantiated, and now I've been demoted or some other thing like that.
Right. So I think that it will vary. It would be hard for me to give a general answer to that. Also, I would yield to my lawyer friend here.
I'm happy to answer that. They would follow the EEO process. So they could go to OHR or they could go to the EEOC to file any claims of retaliation.
And that would then, it's a consistent process in those two places. So it's not subject to how an agency works.
I'm sorry.
That would make it a more consistent process than,
Yes, I mean, you're saying so it doesn't vary agency by agency.
correct?
Correct.
Okay, thank you. I am over my time, but I will be back to you. Thank you very much. Madam Co-Chair.
Thank you. Thank you very much, Chairwoman. I wanted to, let's follow up on this process we were just discussing with Councilmember Nadeau. Can we state very clearly what would happen in a situation where the complainant is not satisfied and does in fact want to elevate the complaint to the next level? Can you sort of give me sort of a trail as to what might happen? Let's say the individual goes to the Office of Human Rights and their complaint is that it was not, whatever happened, I didn't get redress as I expected to in my office where I work. And I'm very disturbed. And so they just happen upon the Office of Human Rights. What do you perceive would be the next step for the complainant?
To clarify, Councilmember, are you saying the complainant is dissatisfied with the result from OHR?
They're dissatisfied with the result from their office.
Okay.
Let's say I work in DPW
Mhm.
and I'm not happy. It
So-
wasn't satisfactory.
So DPW had conducted a
Yes.
personnel investigation of the sexual harassment complaint.
Correct.
And they had issued their findings and the complainant was not satisfied with those findings.
Correct.
Okay. That complainant could choose to pursue a complaint before OHR, as Director Hall mentioned. They could also choose to go to the EEOC, or they could choose to pursue legal remedies in court. So any of those three avenues would be open
Right.
to that.
And I understand that. What I'm asking you put on the record, once the complaint gets to one of those other offices, what can the complainant expect to be the outcome? Because they really want the violator, as they consider to be removed from their job or transferred, or they, the complainant, wants to be transferred from the office where they're working.
So if the complainant goes to OHR or EEOC, a determination will be made at an administrative level there, whether or not there's probable cause for a finding of sexual harassment. I guess I'm not sure what, are you asking like what their remedies are? What?
Exactly.
Okay. So in some cases, they're issued a right to sue letter where they can then go to court with that as well and pursue legal remedies under the DCHRA or Title VII or both. But if they're before OHR, then they have certain legal remedies they can receive under the DCHRA, which I know there are also proposed amendments about that will be discussed today, I believe. So they can seek compensatory, or they can seek any like wages they might be owed before OHR. And with the EEOC, their remedies are similar to those offered under the DCHRA currently, but I think the remedies will be different if the proposed amendments are passed.
Okay, I think that's very important because we're speaking to a great degree to our employees, trying to make sure that they understand what the recourse might be, and how their complaint might be handled. And if the desire is to get Joe Blow removed from his position or me moved to another office, I just wanted it to be clear to the our government public as to what the recourse might be. I think that's very important. That brings me to the issue of confidentiality and the utilization of the show process, where you can go almost anywhere in the government and currently and speak to almost anyone who is trained, as you said, Mr. Hall, to handle these kinds of situations. So what is the thinking from the human resources perspective that you believe would compel an individual employee in our government who's having troubles within their office to go to the show in their office?
So I think a couple things. One, what the mayor's order does is take into account that if the employee would like to go that route, then they can, but it doesn't limit them to it. It provides an opportunity for them to go to a show in another agency. And I think it would vary. The comfort level is going to vary based on the individual. And so that's one of the great things about the mayor's order, is that it does provide that unlimited access to shows to an employee, so that in your scenario, if I'm not comfortable with the show in my agency, I have access to other shows. Keep in mind that I also have access to my supervisor, the supervisor of the person who I'm reporting, as well as the GC. So it's not just limited to the shows. The mayor's order also gives additional avenues.
All right, and so our shows are doing like double job. They have their routine work, and then they have their special trained work that they will do in these situations. Has any thought been given to looking at the amount of time that a show, at least the shows in the 354 cases spent in the negotiations and the interviewing of the parties, and whether or not we probably need at least a handful of shows that do this work on a regular basis, or at least 3/4 time, if not full time?
So I don't think at this juncture we have any information that suggests that they're overwhelmed as it relates to completing the duties of the show and their everyday job. Additionally, keep in mind that that's why it's helpful to have the primary and the secondary, because there are additional avenues for the person who receives the report and then the person who ultimately conducts the investigation as well.
Should we look at the provision though, from the standpoint of the size of an agency? I'm recalling that DC Public Schools, I think 77 complaints, and quite a few, I think over 34 were in one calendar year. If it takes the time that we, the public, were advised it took to look at a pretty infamous case now that was presented to us earlier this year, I would say that it was a full-time job for at least a few months. And so just wondered, I mean, I'm trying to be real about the process. And also understanding that 374 cases were reported to one office, to the MOC. And we know that the MOC maybe doesn't have all of the actual cases. And over a 5-year period, we changed personnel, leadership in various offices. So we may not have all that may have occurred. So given that, I'm just trying to examine whether or not we have any data, any sense of the time frame that it takes, and whether or not there is a need to have, a few dedicated individuals that would be focused and available. And I'll share with you this really quickly. I'll try to be quick. The Metropolitan Police Department has a process which I thought was very interesting, where they sort of like an individual actually visits the various offices and just sort of like observes. It's their own personnel. But if they see something that looks a little peculiar, like, I might, oh, let me see this, and I'm all in, do you see what I mean? And then they will call the parties in and say, you don't want to do that because it looks like you are. So a preventive, just wonder if you have any thoughts about that.
I think my thought would be that the objective of the mayor's order is to make all of us responsible for preventing sexual harassment and not limiting it to a subset of employees. In addition, it gives us the avenue for reporting it when we see something and a process for investigating it. I think that as it relates to the data that you inquired about, one of the good things about the task force is this is something that they'll be able to consistently review and to be able to see, is there a need for us to make any changes, not just to the show process, but to the number of shows or the way that shows operate. That is something that they'll consistently be able to review.
And I agree, the task force could have that responsibility, but how will the data be collected that talks about time frame and all? But I'm out of time. I think, yeah, I'm out of time. Thank you.
You're welcome.
Thank you very much. Thank you, all three of you.
Thank you, Madam Co-Chair. Just picking up where I left off, we were talking about retaliation and referrals to EEOC and OHR. So if somebody does go to either OHR or EEOC for a retaliation claim, how does that process work?
Would follow the standard EEO process where they first begin with an EEO counselor to file their claim. And then the counselor seeks to mediate that claim with the agency. If that's unsuccessful, the individual is able to file their complaint with OHR or the EEOC.
Okay. Oh, I see. So EE is not EEOC. That's something before. Okay. So where does that office reside?
EEOC?
The EE that you meant. Okay.
Oh, the EEO counselor. Sorry, is that what you're talking about?
Yeah.
So each agency is responsible for having an EEO counselor. And
Got
so
it.
you can go to your EEO counselor at your agency, or you can go to an EEO counselor at any other agency.
Got it.
Typically, employees go to EEO counselors outside of the agency. I mean, that's very common. So,
Right. Because at that point, they're concerned about retaliation within the agency in the scenario we're talking about. Okay. So, and then at OHR, I'm familiar with their process, so you can skip that one. Okay. Thank you. Director, can you share any knowledge of enforcement trends you're seeing based on the sexual harassment data the agency collects? And can the agency send any data you have over here to my committee as well?
Can you repeat that one for me?
Can you share are you seeing any trends in the sexual harassment data the agency collects regarding enforcement and how it's being handled?
Got it. So DCHR does not directly collect all data. So I would not be able to speak to that from a DCHR perspective.
Who does that?
Some of it is, well, it depends on the path that someone takes. So if they go to the court, of course, DCHR would not have that access. It could be an avenue that they take to EEOC or OHR. We wouldn't have access to that information either. So it would only be information that literally is through the show process and reported to our general counsel.
Do we think there should be a central repository for all of that data?
I believe, and please correct me if I'm wrong, but the MOLC would get any employee information that comes straight through our show process.
That currently, agencies are required to file a notice of complaint with the MOLC when they receive a complaint of sexual harassment by an employee at their agency. And then they are also required to submit a copy to MOLC of the findings and conclusions that they issue at the end of an investigation.
As part of the show process?
Correct. Meaning as part of this personnel investigation of sexual harassment. So not part of an EEO process, not part of any court litigation.
So does anybody in the executive branch have the court information?
OAG presumably, who represents the district, would have it.
But we don't know? And
I
what
don't
if-
know that they track it. I
Yeah.
can't speak to how they track.
And does anybody in the district government have the EEOC data? Does that go to anybody?
I believe when an employee files with the EEOC, it is also, or it can be cross-filed with OHR. So OHR would have knowledge of that when it's cross-filed. Otherwise, it would have to be each of the agencies would be notified when a complaint has been filed with the EEOC.
Okay. It does seem like that is an information gap if we have folks collecting in different places in different parts of, and different governments. And that may be something that we need to address as well. Thank you for that information. The bill names specific positions that would be subject to its provisions. So mayoral appointees, including agency and sub-agency heads, deputy mayors, and those appointed to boards and commissions. Do these positions of power seem like the right ones to you? Are there any others we should consider?
Or referring to outside counsel. Of course, like we, MOLC and the government will follow whatever law is passed. I think the question I have is how that abrogates the current EEO process. It seems to remove the right to a final agency decision for certain employees based on who has harassed them. I think the EEO process is tried and tested, and it's something that is has a lot of case law supporting it. I think it's much harder when we start to talk about giving those functions to an outside entity that's not government, that doesn't necessarily have the same requirements for confidentiality. I think, at least speaking for our office, that did conduct a high-level investigation. It took over 1,000 hours of our show's time, which I can't even imagine if we were billing billable hours for that, what that would be. But also the idea, I guess it feels like to me, there is still, first of all, like the idea that the show should be someone who's not answering to the alleged harasser is important. I think that does help provide impartiality. And the reason, I think that is one level of impartiality that's already built into the show system. I think the other part is the idea that you're not limited to a show investigation. This is a personnel investigation that's designed to help the mayor identify issues before they turn into perhaps legal cases of sexual harassment. It's designed to help us recognize any trends that we might see in agencies, to mitigate risks. But if someone has any questions about the impartiality of their investigation, or they have concerns that they won't get a fair hearing, I would encourage them to go to OHR or to the EEOC if they have concerns about that. They are entitled to that, and nothing in the mayor's order prevents them from doing so.
So the mayor's order already refers certain allegations to the OIG and independent counsel, right?
Correct.
Okay, so my question is, just my bill names more people. Are those the right people? So the mayor's bill is just cabinet. What made those people the right ones for the mayor? As compared to what I've added, which is also agency and sub-agency heads and deputy mayors and those appointed to boards and commissions, all people who wield significant power in the District of Columbia.
I mean, I feel like that's a policy answer that you're asking for, and
Yeah.
that's not my role to give that.
Okay, but does the mayor's order subrogate the EEO process?
No, because the distinction between what the mayor's order is doing and what the proposed legislation is doing is the proposed legislation is amending the DC Human Rights Act. The mayor's order is a personnel investigation that she's giving to an outside entity to avoid any concern that there's, partiality for these high-level government officials. I think the difference here is that we're saying instead of the EEO process, you will now go to an outside law firm to get these findings.
Got it. I haven't. Out of order here. Yes, I have. Okay. Ms. Nowhere, you worked on the summary of findings from the sexual harassment investigative report, right?
The findings and conclusions, the summary of findings.
Yeah, the Mulks investigation of the allegations.
Yes, I assisted in it. I was not this show. I was not the investigator.
Okay. And the Mulk conducted 2 investigations regarding the sexual harassment complaints against John Falchecchio, right?
Correct. There are 2 complainants.
Okay. And the Mulk published 2 reports on their own internal investigation, is that right?
So there's there's an investigative report by the show, and that's not released. That's confidential personnel information. We need to also protect the confidentiality of witnesses and the allegations made by the complainant says they're sensitive.
Got it.
But the findings and conclusions, or a summary of the findings of conclusions, were published. Yes.
Great. All right. I'll come back to you on that. I'll turn now to my co-chair, Councilmember Bonds.
Thank you again, Chairwoman. I just wanted to talk a little bit about the issue of confidentiality. I think through the show process, we envision it to be confidential. But if we go to an outside source, what kind of guarantees do you see us, or what kind of wall do we need to put in place? And Mr. Lucas, I guess that's really a question for you, because you would be drafting this request for services. And have you, in the copies or in the contracting that you have attempted to do, gotten any feedback from anyone who might be interested inquiring about confidentiality and how they would handle the measure? All right, and so in exercising your judgment, let's talk about that for a minute. What's the criteria that you use for deciding that a matter moves from confidential level to transparency, disclosure, and in the public domain, as an example?
We want to hear everything you
Okay.
guys say.
I forgot again.
For me, it remains confidential unless it's required in order to solve a problem. That's rare. We try to protect confidentiality as much as possible. That is, I'm not going to disclose something if it adds no value what we're dealing with.
So can you envision in implementing the law we're examining or the proposal we're examining today, a circumstance or circumstances that would invite an opportunity for you to disclose what might be confidential?
No, not off the top of my head. We'll cross that bridge when we come to
And what kind of bridge would that be?
a confidential one.
I know the answers, but oh my goodness. Let me ask you, Ms. Noteware, the data that ultimately makes its way to, and I call it data, but I know it's reports, to your office. And thank you again for the redacted information. We were able to get redacted information similar to what I presume was shared with the Washington Post. So that's for everyone to know. We have no special anything. And our survey really requested that we not be given dates and names or anything, just, incidents. In the data that you reviewed, obviously, that comes to your office, do you see any trends of whether or not there is or there has been needs for sort of re-examining the information? I can remember one situation where I believe I read where the allegation was, again, like my colleague mentioned, where there was some touching, but it was, the report said, unsubstantiated. What would be the guideline that you would need to re-examine something that says physical situation had happened, but in a report, it says unsubstantiated? Would you need witnesses or reference to there being witnesses that had observed it to change it to substantiated from the unsubstantiated?
There's a number of reasons why an allegation might be unsubstantiated. It could be that the credibility of the person making the allegations, right? There's a whole host of factors that a show is trained on to look at in assessing someone's credibility. And so that can be part of it. Sometimes the complainant chooses not to participate in an investigation. In that case, also, it's very difficult to substantiate. So anytime that you only have one side of the story, it's going to be harder. I think that's why the training for shows, in order to be able to assess these things, is important. I think it's also why it's important that this is not their only avenue to pursue any remedies to sexual harassment. It's one avenue, and it's one that we hope helps us to prevent sexual harassment and root it out quickly where it does occur. But it certainly doesn't preclude them from going to other avenues where they might have more opportunities to get more evidence. Let's say if they pursued legal remedies in court in the discovery process, they would have a lot more breadth in the kind of materials that they could seek from the other party and things like that, like text messages or something, if they needed that to substantiate their claims.
All right, I wanted to quickly look over portions of the mayor's order, and do you recall whether or not the new order stipulates an avenue recourse for a unhappy complainant, which would lead them to advising that they do and can use the courts if they're unhappy, which probably is the ultimate arbitrator of any case. Do you recall, Mr. Hall?
Let me make sure I have the question correctly. Does the order provide a way for an employee to understand that they can use the court? Yes,
Correct.
ma'am, it does.
All right, that's important. You didn't mention it before, so I want to make sure. All right. I have no further questions, Chairwoman, and I want to thank the panel very, very much. Again, outstanding panel representing parts of the government that happen to be in my committee. I thank you so much. Thank you.
Thank you, Madam Chair, for co-chairing the hearing today, and I look forward to hearing more about your new bill, which I think I hear incorporates this bill. So sounds like we're all on the
Working
same
together.
page. Yep.
Yes. Mhm.
Okay. All right. Back to Ms. Noteware. I just want to make it really clear, have you make it really clear. The investigation into the Falchecchio allegations was done by the Mulk show or a Mulk show.
Correct.
Okay, great. During Mulk's investigation, the agency findings in the report showed that some allegations were either substantiated in part, or were found to be unsubstantiated. The findings were based pursuant to the mayor's 2017 sexual harassment order. Is that correct?
Correct.
Were the findings pursuant to any other regulations, local laws, such as the DC Human Rights Act or federal law?
The investigator, I believe, used the updated definition of sexual harassment from the DCHRA in her investigation.
Okay, and what laws was the Mulk considering in their reports? Was it only DCHRA and the mayor's order, or was there more under consideration?
Primarily, the investigation's determining whether or not there's a violation of the mayor's order. That's what is being substantiated or unsubstantiated. In assessing whether or not sexual harassment has occurred, looking at the broadest definition possible of sexual harassment, I believe, is what the investigator chose to do in this, in the sense that the DCHRA had been newly or more newly amended than Title VII, at least, in terms of expanding the definition of sexual harassment, which was considered in the investigation.
In your opinion, what are the potential risks of relying on internal sexual harassment investigations? And I guess more specifically, with the Mulk, the optics of how close in reporting structure the Mulk is to Mayor Bowser?
I think the risk would be different if the allegations had been made against someone the director to the Mulk reported to. If we had been in the chain of command of the person the allegations had been made against, I think that could look more like a conflict of interest, or, at least give the appearance of impartiality, of partiality. I think that's more the risk that I would see, as opposed to like the closeness to the mayor, because the allegations weren't made against the mayor.
What is the chain of command for the Mulk?
The director of the MOLC answers directly to the mayor.
Okay. And how did the MOLC ensure the two investigations into Falchecchio's misconduct, which led to the summary of findings, were free of any internal conflicts?
The show was incredibly conscientious about interviewing anyone and everyone that the complainants thought might have any knowledge of the allegations. The investigator also asked every witness who was interviewed whether or not they knew of anyone who might know anything of the allegations. At no point was the investigator told, you can't talk to this person, nor was she steered to talk to certain people. It was purely predicated on who was willing to talk to the investigator, who was not a DC government employee. DC government employees are required to participate in investigations. Besides the complainants, they are not required. But if they were former government employees, the show was only able to speak to them if they agreed to participate in the investigation.
Can you discuss the importance of transparent investigations that protect victims and don't make them relive their experiences? And what did the MOLC show do to minimize that during the investigation?
I think everyone can agree that it's incredibly important that that allegations are taken seriously and that they are listened to fully and carefully, so that there's not a need to continue to go back to the same points that might be painful for the person who is recounting them. I had the chance to listen to many of the interviews as I was helping with transcription of them. I can say from my own perspective, the show was incredibly compassionate at listening and allowing breaks when necessary. Counsel was present with the complainants during their interviews. I think the fact that every allegation they made that related to sexual harassment that was covered by the mayor's order was taken seriously and subsequently investigated, that the show reviewed any documents that they provided, right, to support it, which was thousands of documents, right, that were reviewed. I think taking it seriously is the most important thing we can do to allow the complainant to feel that their efforts to bring this forward aren't in vain, and that that this is not an unnecessary trauma.
Thank you. With respect to the MOLC's findings, just so we have this clearly in one place, what methodology was used to investigate the allegations?
I'm sorry, I'm not sure I'm understanding the question.
How did the show go about conducting the investigation? What was the procedure in the process?
Okay. The show followed the procedures that are outlined in the DCHR guidance on conducting a sexual harassment investigation. But initially, the show interviewed the complainants to make sure that the show had a list of all of the allegations that the complainant was alleging, and then began to interview employees, again, based on those identified by the complainant, and any others that the show might have any information to give regarding the allegations made. So anyone who might have witnessed anything, people who worked closely with the individuals named and things like that.
And can you share some best practices that MOLC employs for this type of investigation?
I think in terms of, I think as I mentioned before, in terms of making sure that you have a clear understanding of all the allegations made by the complainant, and a clear understanding from the complainant themselves of anyone who might have knowledge that you're able to speak to, any supporting documentation that they might have. Getting those from the complainant at the beginning to help guide the investigation. I believe also you know, the idea that these interviews are confidential with the show is an important best practice for us to follow, in the sense that it's not just for the complainants, but also witnesses can be hesitant to speak if they feel like it's going to be divulged later, or that someone might find out. So the fact that that confidentiality was discussed before any conversations took place with the complainants, with the witnesses, or potential witnesses, I think that's also another important best practice that we followed.
Thank you. I know you heard me discussing with Director Hall the Washington Post article. Let's see. Where they obtained through records requests the collection of MOLC data, which shows all sexual harassment complaints investigated under Mayor's 2017 order. Of the 290 complaints reviewed from December 17th to December 23, just under 30% were substantiated in full or in part, and about 40% of the complaints were unsubstantiated or were inconclusive. With respect to how MOLC makes its own findings, what does it mean when an allegation is substantiated? And can you walk me through how MOLC comes to that conclusion?
Sure. So just to clarify, the findings that something is substantiated or unsubstantiated lie with the agency. So MOLC doesn't make them for all of the agencies.
Okay.
That's not us. And as I mentioned to Chairperson Bonds, there's a number of reasons why something might be unsubstantiated.
Mhm.
But the standard to be used is whether or not something more likely than not occurred. So that's the standard used in determining ultimately whether the evidence presented makes it more likely than not that that allegation occurred, or yeah. So that's what determines whether or not something has been substantiated.
Okay. And how does an agency come to that conclusion?
So the agency has the show's investigative report to review, and that show under the 2017 mayor's order, that show made recommendations. And then the agency reviewed the evidence presented by the show and made the determination whether they found the allegations to be substantiated or not.
And within an agency, is that usually the general counsel, the director? Who would it be?
Typically, the general counsel working in conjunction with the director.
What does it mean when an allegation is substantiated in part?
It can be that the allegation might have different parts to it, right? So one part of it might have had enough evidence to, or more likely than not, that it occurred, while a conclusion to it, right? And a complainant might say, they took assignments away from me because I wouldn't sleep with them, right? They might say something like that, right? And perhaps there is evidence to support that assignments were taken away, but there's not evidence to support that it was in retaliation to any, sexual requests. So a part of an allegation could be substantiated in that respect.
What does it mean when an allegation is found to be inconclusive?
I would assume that that means that there's not evidence to substantiate it. I would say unsubstantiated, but an agency might have its own reasons for saying inconclusive.
Okay. Recently, the mayor updated her sexual harassment policy and adopted the standard that was introduced in this bill, which would require sexual harassment allegations for top-level government officials to be referred to the IG. I was glad to see that. And what's your position on having some of MOLC's jurisdiction transferred to OIG?
I don't think it's MOLC's jurisdiction. I think, again, as we kind of mentioned before, The mayor's made a policy decision, it seems, to give investigations to an outside entity where there could be any concern that there might be bias. But again, I don't think it necessarily like took away any jurisdiction. I think it's more that an idea of let's take away any kind of perception of partiality.
Okay. That'll conclude the joint part of the hearing on this particular bill. I am grateful for all of your participation and testimony and look forward to working with you as the bill advances. Thank you so much. We'll now move on to the three other bills under this committee's consideration. B 25-432, the Self-Storage Lien Enforcement Modernization Amendment Act of 2023. Bill 25-330, the Office of Administrative Hearings Jurisdiction Amendment Act of 2023. And B Bill 25-319, the Fairness and Human Rights Administration Amendment Act of 2023. The first item on the agenda, the Self-Storage Lien Enforcement Modernization Amendment Act of 2023. This legislation was introduced in July 14th, 2023 by Councilmember Gray. The bill would amend the Self-Storage Act of July 2003 to grant more flexibility to self-storage facilities to alleviate burdens related to abandoned vehicles, watercrafts, and trailers. Thank you. Specifically, it grants facilities the ability to have these vehicles towed away and to better advertise property put up for sale. The legislation also adjusts mailing requirements related to notification, allowing facilities to contact owners via certificate of mail and for notifications of liens to be sent directly to facility business centers. The second item we will discuss is Bill 25-330, the Office of Administrative Hearings Jurisdiction Amendment Act of 2023. The legislation was introduced on June 28th, 2023 by Chairman Mendelson at the request of the mayor and subsequently referred to the Committee on Public Works and Operations. Concealed pistol licenses and firearm registration certificates are issued by the Metropolitan Police Department. An individual who's denied a concealed pistol license or firearm registration certificate or has an existing license or certificate revoked may file an appeal. Jurisdiction for concealed pistol license appeals moved from the Concealed Pistol Licensing Review Board to the Office of Administrative Hearings as of October 1st, 2023. OAH already adjudicates firearms registration certificate appeals. This draft bill changes the burden of proof in an evidentiary proceeding for an appeal of a denial or revocation of a concealed pistol license or a firearm registration certificate from the applicant or licensee to the Chief of the Metropolitan Police Department. Finally, the third item we'll discuss is Bill 25-319, the Fairness and Human Rights Administration Amendment Act of 2023. The legislation would allow withdrawal without prejudice of certain administrative complaints of unlawful discrimination by the district government. The bill would allow withdrawal without prejudice against private parties at any time. The bill provides that injured parties are entitled to compensatory damage and reasonable attorney's fees and would permit the Commission on Human Rights to award punitive damages. The bill also seeks to permit civil actions in D.C. Superior Court even after a finding of probable cause is issued by the Office of Human Rights or Commission on Human Rights. Additionally, throughout the hearing, we will also consider changes to other awards and damages, expanding the definition of sexual harassment and expanding the statute of limitations in sexual harassment cases from 1 year to 3 years. Okay, so now we'll hear from our public witnesses and we'll start the panel that will be testifying on the Self-Storage Lien Enforcement Modernization Amendment Act of 2023. This panel includes Bruce Bariano, Self-Storage Association, DC Self-Storage Association, Daniel Bryant, Legal Counsel with the DC Self-Storage Association, Jennifer Martinez, Vice President of Operations, Self-Storage Plus Management, LLC, Craig Russell, U-Haul Company of Metro DC. Mr. Bariano, you may begin when you're ready. I'm sorry. Before you begin, Mr. Bariano, we've been joined by our Ward 7 colleague and the author of this bill, Councilmember Vincent Gray. Councilmember Gray, if you'd like to make any remarks, the floor is yours.
Fine, Councilmember. We can go ahead with the efforts at this point.
Wonderful. Thank you. Mr. Bariano, you may begin.
Thank you. Good morning, Madam Chair. It's an honor to be before this committee. And I want to thank my fraternity brother of long standing, Ward 7 Councilmember Vince Gray, for introducing this legislation on behalf of my client, the District of Columbia Self-Storage Association. This is a very basic, simple bill. Very much need to change the law on self-storage operations in the District of Columbia to modernize, I say that respectfully, that law as has been done in so many other states across the country in 4 areas. One dealing with notices for default notices, also dealing with auctions. They can be online instead of being in person. Making the towing operations if a vehicle or has been abandoned in a storage area so that it can be towed away, and then it's a much less complicated matter, and it is still securing the vehicle. And then lastly, a newspaper advertising, which is required, and now so many people read things online. It is actions that in so many other states, Madam Chair and members of the committee, these changes have been made. We made them in the we made them in the state of Maryland, respectfully, about 7, 8 years ago. We made them in the state of Virginia. And it was just to modernize because things have changed. People don't read newspapers as much. People do things online. You can reach a larger audience if you're trying to auction items to sell things, not only for the operator of the self-storage, but any leftover proceeds go to the person that rented that owes the money. So there has been, the important thing is that these changes we're proposing, very respectfully, have been in place in so many other states and your neighboring states for a period of time, and there have been absolutely no problems, no objections, no complaints by consumers, no allegations of taking advantage of renters of self-storage. It really helps the renter, the utilizer of the self-storage in options, in notification, and if unfortunately there is a default, a live auction gets a lot more people than putting something in the newspaper. So we would respectfully urge the passage. Again, I thank Councilman Gray on this, and see that the District of Columbia can do what they want, but I'll just say in conclusion that you've seen these changes being made and in operation in so many other jurisdictions that they've helped. There's been no problem. And we just want to modernize respectfully the District of Columbia's lien laws and operation laws on self-storage. I thank you again. And let me just say, your staff person is phenomenal on your committee. I've really enjoyed working with her. I look forward to meeting her at some point, but very professional. And I mean that sincerely. Thank you for the opportunity to testify. And thank you, Councilman Gray.
Thank you. She's blushing right here in the chamber for that. So thank you for your testimony, and we will now turn to Daniel Bryant.
Chair Nadeau, members of the committee, thank you for the opportunity to testify today. My name is Daniel Bryant, and I serve as legal and legislative counsel to the National Self-Storage Association based in Alexandria, Virginia. As for your support today for B25-0432, the Self-Storage Lien Enforcement Modernization Amendment Act of 2023. Today, I wanted to provide a national overview of the adoption status of these changes that are proposed in the bill. First, the bill would permit owners to send the second default notice by U.S. mail with a certificate of mailing, PS Form 3817, in lieu of certified mail. To date, 47 states permit owners to send default notices via U.S. mail with a certificate of mailing, including both Virginia and Maryland. Second, the bill would permit vehicle towing. The change would permit storage owners to have vehicles towed from the facility following a default in lieu of selling it. To date, 46 states have adopted a towing amendment that permits storage owners to tow property under similar circumstances, again, including both Virginia and Maryland. Third, the bill would expressly permit storage owners to conduct lien sales online in addition to in person at the facility. Several websites conduct these sales for the industry, and more than 40 states have expressly adopted amendments to permit those types of sales, again, including both Virginia and Maryland. Finally, the bill would permit storage owners to advertise lien sales on a publicly accessible website that customarily advertises or conducts property sales. To date, 32 states permit owners to advertise via an alternative mechanism or have no advertising requirement at all, again, including both Virginia and Maryland. Overall, this bill truly modernizes the lien enforcement process to make it consistent with the overwhelming majority of states. All of these proposed amendments are codified in both Virginia and Maryland law. Ask for your support for the bill, and thank you again for the opportunity to testify today.
Thank you very much for your testimony. We'll now hear from Jennifer Martinez.
Chair Nadeau and Chair Bonds and members of the committees. Thank you for the opportunity to testify today. My name is Jennifer Martinez. I'm the Vice President of Operations for Self Storage Plus. We have 3 facilities in the District of Columbia. Self Storage Plus also operates 57 facilities in Maryland and Virginia. I ask for your support today for B250432, the Self Storage Lien Enforcement Modernization Amendment Act of 2023, a bill, as the name suggests, meant to modernize the self-storage lien process in the district. As a bit of background, our industry is not in the business of selling the possessions of individuals or former customers. We are in the storage space rental business. However, sometimes sales are required when tenants do not pay rent to recoup the debt, and more importantly, return that unit back to inventory so that it may be rented again to a paying customer. The law requires that our rental agreements apprise tenants in bold type of the existence of our lien rights and that the property may be sold to satisfy the lien upon default. Additionally, the law requires 2 direct notices to the tenant before the sale may proceed. In practice, local managers will attempt to contact the delinquent tenant multiple times before proceeding to the sale through various forms of communication like email, traditional mail, phone calls, and text messages. Resolving the payment dispute in a way that does not require sale is always preferable, as lien sales rarely bring in even 30% of outstanding debt. After all attempts to contact the tenant and resolve the payment dispute fail, District of Columbia law requires that the operator advertise the sale in the newspaper of general circulation before conducting it. The purpose of the advertisement is not to reach the tenant. That purpose has already been satisfied through direct notices. Current DC law does not even require the publication of the tenant's name in the advertisement. Newspapers were once the most effective means to advertise upcoming sales and drive traffic to it. That is simply no longer the case. Alternatively, advertising on online auction websites is more effective at reaching the target audience of potential bidders. Maryland permits this form of alternative advertising. Virginia does not require any form of advertising before proceeding to sale. Additionally, the bill would permit towing vehicles. Presently, when an occupant defaults on the space and the property is a vehicle, the only remedy is to sell the vehicle to enforce the lien rights. Many storage operators do not want to go through the DMV process for selling a titled vehicle. The process can be cumbersome, and many operators are not frequently called upon to do so. The proposed legislation would provide operators with the option to have certain property towed instead of selling it. Towing can also be beneficial for tenants as the property is merely relocated to a towing facility in lieu of selling it. The towing company would have to comply with the process for selling the titled property. Both Virginia and Maryland permit towing under similar circumstances. Overall, the bill seeks to bring the act in line with modernization efforts in other states. All of these changes have been adopted and implemented in both Virginia and Maryland. Operating 57 facilities in those jurisdictions, I have seen these changes implemented successfully. I respectfully request your support for the bill. Thank you again for permitting me to testify today. I'd be happy to answer any questions.
Thank you very much. And I do not see Craig Russell here. So I thank you for your testimony. Some of you touched on this, but what are the current challenges that storage facilities are facing related to abandoned vehicles, watercrafts, and trailers and other large items that might be left behind in storage units? And how is it impacting business operations and revenue? Anyone can answer.
I can speak on that. Do I need to tell you who I am again?
Nope, you're good.
Okay.
Thank you.
So the challenges that we face is the DMV process to sell a vehicle, again, is very cumbersome. It creates an issue where there's multiple steps that need to be taken, which causes the length of time of that debt to extend past the normal time frame that we would like for a customer to incur debt for. So it causes us to not be able to get our space back in a reasonable amount of time. And it also causes the debt owed by the customer to continue to increase. I would say that's the biggest issue.
Madam Chair, may I say something?
Absolutely.
Did you hear me? Can you hear me all right?
Yes.
Adam,
Oh, you got muted again. Yeah.
Can you hear me all right now?
Yes. Somehow you got muted again.
All right. You can hear me now?
Yep.
Can you hear me?
Yes, I can.
Yes. Sorry, I was just going to add, Ms. Martinez, also, and they would know better than I, these storage facilities only have limited space. So if these items are hanging around for longer than they otherwise would be and can't be towed, you can't do business with other people that either want to store a car or a boat or a trailer in that facility. So it does back up business and make it more difficult in some of the facilities. I just wanted to add that to your excellent question of why it's very helpful. If you see that they're not claiming if you can tow it away, but you're not damaging the vehicle, it still has all the safeguards, but you've got your space that you can utilize for further rentals. That's common sense business. Thank you very much.
Thank you. And Ms. Martinez, how many abandoned vehicles are your facilities storing at any given time?
In the District of Columbia, I would say on average 2 or 3. But to the point of we have very limited space, I would say, we only have probably 20 parking spaces that we have the ability to rent at any time.
So 20 to 30%.
Yes.
Yeah. Okay. And how often do attempted sales of vehicles actually result in the sale and eventual removal of a vehicle?
Not very often. The process, again, is very cumbersome. Sometimes it's easier, and to my point earlier, if the customer has been storing with us for 6 months but hasn't been paying and we eventually get a hold of them, we tend to just work something out and get them their vehicle because the process through the DMV is more cumbersome.
And how much time and resources are spent in the attempt to sell a vehicle?
Oh, I would say over the course of, let's say 2 or 3 months, because that's ideally the time frame that we would like to see be able to get that space back between the time of having the in-store managers visit the DMV, contacting customers. I would say upwards of 24 hours across 2 or 3 months per customer.
How much time and resources are facilitated spending on attempts to contact owners via certified mail? And how often do the mailers result in action or response?
The mailers, 99.9% of the time come back to us as undeliverable because certified mail can't be forwarded. So sometimes that, again, makes it, adds additional time frame, because then we have to recertify within the allotted time frame if we were to get an additional address. And the cost that goes into it, we probably spend, I don't have the numbers right here in front of me, but I would say on average, we probably spend $300 to $400 a month just on certified mail at one facility.
Great. Unless anyone else has anything to add, I'll turn to my colleague, Councilmember Gray.
We have no questions at this time, Madam Chair.
Thank you. Well, thank you all very much for your testimony. Appreciate it.
Thank you very much.
Our next panel includes Rachel Green with Katz Banks Cumin LLP, Doug Kim with National Women's Law Center, Scott Michaelman, Legal Director of ACLU DC, Jonathan Puth, Metropolitan Washington Employment Lawyers Association, Micah Saab, Laura Brown, Executive Director of the First Shift Justice Project, Robert Fitzpatrick, Stephen Pershing, College RV Hootsie, Newman and Fitch, PC, Frank Silberstein, American Federation for Government Employees. Okay, so as folks are coming on, oops, I move my laptop to see you better. It also moves my camera. Funny how that works. Okay. Just 1 second. We're getting everybody settled. Oh, hi, you're here. I'm like waiting for you to come onto the screen. Hybrid means hybrid. Okay. So our first public witness is actually here in person. So we'll hear from Rachel Green.
Hi, good morning. Thank you to Councilmember Nadeau and members of the committee. My name is Rachel Green, and I am testifying about expanding the definition of sexual harassment in the DCHRA. As an associate of a DC law firm, Katz Banks Cumin, my practice is often devoted to the representation of people who have experienced sexual harassment at work. And in my firm's practice, we have come across a likely unforeseen gap in the DCHRA's application to the new federal law restricting mandatory arbitration clauses. And this is the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which was signed into law in March of 2022. The Ending Forced Arbitration Act bans employers from requiring employees to arbitrate disputes related to sexual assault or sexual harassment. There are many studies concluding that mandatory arbitration provisions systematically disadvantage employees, including by removing the powerful threat of public pressure that is inherent in a court proceeding. And so the Ending Forced Arbitration Act expands routes to justice for employees with claims of sexual assault or sexual harassment by permitting them to escape arbitration. What exactly constitutes sexual harassment is what determines whether an employee can escape arbitration under this new federal law. And federal courts have defined sexual harassment broadly to include hostility based on sex, gender expression, gender identity, or sexual orientation, even absent conduct of a sexual nature. However, the DCHRA restricts sexual harassment to include only harassment of a sexual nature or sexual advances. So these entire categories of harassment based on sex, sexual orientation, gender, or gender identity, therefore, are not sexual harassment. And to be clear, the DCHRA does prohibit each of those categories of harassment, but not as sexual harassment. And the implications of this gap are significant. The DCHRA offers a longer statute of limitations than that for Title VII claims. It does not limit compensatory damages, while Title VII does. And the recent DCHRA amendments lowered the burden for demonstrating harassment to totality of the circumstances, while Title VII claims must still meet the severe or pervasive standard. And so to ensure that DC employees can take advantage of the Federal Ending Forced Arbitration Act with their DCHRA claims to the same extent as they can with their Title VII claims, I propose amending the DCHRA to expand this definition of sexual harassment to constitute, and I have it in my written testimony as well, so I have much more detail there, to constitute gender-based conduct, including conduct based on sex, sexual orientation, gender identity, or gender expression. And I'm happy to provide citations or answer questions. And thank you for the opportunity to testify.
Thank you for your testimony. Okay, I see Da-Hae Kim has joined us, and you may begin your testimony when you're ready.
Great. Good morning, Chairs Nadeau, Bonds, and members of the committee. My name is Da-Hae Kim, and I'm here to testify on behalf of the National Women's Law Center. Today, I'm here to discuss B25-0319. And since 1972, the National Women's Law Center has fought for gender justice in the courts, in public policy, and in our society, working across the issues that are central to the lives of women and girls. The National Women's Law Center Fund also houses and administers the Times Up Legal Defense Fund, which provides funding for legal representation and storytelling assistance in select matters challenging workplace sex harassment and related retaliation. Since its founding, the Times Up Legal Defense Fund has received over 5,000 requests for assistance. The DC Human Rights Act currently defines sexual harassment as behavior that is sexual in nature and excludes harassment that does not include sexual conduct, but that is nevertheless sex-based from the definition. The DCHRA's narrow definition of sexual harassment is inconsistent with Title VII of the Civil Rights Act of 1964, as well as several state anti-discrimination laws. Federal courts have recognized harassment as a form of sex discrimination that is prohibited under Title VII, and sex-based conduct may create a hostile work environment, whether or not the conduct is sexual in nature. For example, under Title VII, it is sexual harassment if a supervisor says he doesn't think a woman should have the employee's job and insults or ridicules the employee or gives the employee impossible tasks because the employee is a woman. Moreover, under the recent Federal Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, individuals asserting sexual assault or sexual harassment claims under federal, state, or tribal law must be given the option to bring those claims in court instead of being forced into arbitration, which is notoriously unfavorable to employees. An employee is only protected under this federal act if the conduct they experience could form the basis of a claim of sexual harassment under a federal, state, or tribal law. And an employee who would be able to use this federal act if they brought sexual harassment claims under another jurisdiction, for example, another jurisdiction's employment anti-discrimination law, may not be able to rely on this new federal act if they were to bring a sexual harassment claim under DCHRA. Forced arbitration is an all too common tactic of silencing survivors and letting harassers evade accountability and behave with impunity. And it disproportionately impacts women and people of color. Employees cannot negotiate their arbitration agreements. Employers choose the rules, employers choose the arbitration forum, and employers choose the arbitrator. Additionally, a key barrier to workers' ability to access justice is short statutes of limitations. What we see through the Times Up Legal Defense Fund and our work with survivors and advocates across the country is that many workers do not come forward immediately or even within the first several months to report sexual harassment, often due to a fear of retaliation, shame, blame, and fear of not being believed when they do share their experiences. Of those who do report sexual harassment to Time's Up Legal Defense Fund, over 70% reported that they had been retaliated against when they complained about harassment, and that includes being fired or even being threatened with physical harm. And financial constraints can also present barriers to timely reporting, particularly for low-paid workers who may not have the time and resources needed to find or consult with advocates or attorneys about their rights, and who need to prioritize finding a new job to keep food on their tables. As a result of all this, we see that many people seeking assistance have run out of time and no longer have legal options available to them to seek justice. If DC extends the DCHRA statute of limitations, it would join a host of states like Maryland and New York who have extended their statutes of limitations for discrimination and or harassment claims since #MeToo went viral. Thank you for your time, and I am happy to answer any questions.
Thank you so much for your testimony. I want to note just logistics here. Micah, we need you to accept the panelist invite so that you can join us up here. And we do not believe that Robert Fitzpatrick has joined the Zoom, but Robert, if you're in under another name or something, just raise your hand and we'll help figure it out. Thank you for that brief announcement. Okay, we will now move to Scott Michelman. Good, we got Micah up. Great.
Unmute. Thank
There you
you. Good morning. My name is Scott Michelman, and I am the legal director of the ACLU of the District of Columbia. I present the following testimony on behalf of our more than 14,000 members and supporters across the district. The ACLU is a nonpartisan nonprofit that protects and advances civil liberties for people who live in, work in, and visit DC. We share the goal of the DC Human Rights Act to secure an end to unlawful discrimination in the District of Columbia. The DCHRA is one of the most potent tools available in DC law to challenge private and governmental discrimination, but it is not working as well as it should. Though impressive in its breadth, the DCHRA suffers from a key flaw. Except as to discrimination in real estate transactions, individuals who have suffered discrimination can enforce their rights only within 1 year of the discrimination. Picking up on the suggestion of the previous witness, we urge the DC Council to extend the DCHRA's limitations period from 1 to 3 years for all claims of discrimination. There are two problems with the 1 year period. It is too short on a practical level, and it is stingier than 2/3 of states nationwide. I'll expand on each in turn. First, 1 year is too short for victims of discrimination to bring an action. When someone has suffered discrimination, the path to filing a complaint, either with OHR or in court, can be long. Victims of discrimination may not begin the search for counsel right away because they may not immediately know their rights or understand that what happened to them violated the law. Once they recognize they may have legal options, finding a lawyer is often difficult and time-consuming. Many lawyers won't take discrimination cases because the damages may be low or hard to prove. When lawyers are open to such cases, they need time, weeks or months usually, to investigate. Investigations may require speaking to numerous witnesses who may not easily be found. All of this must happen before a complaint can be filed. In the ACLU DC's experience, the sharply limited time afforded by the 1 year statute of limitations presents significant challenges given the time required to investigate and prepare a complaint. When evaluating requests for legal help on discrimination matters, the 1 year deadline is a significant factor in how we proceed or even whether we can proceed. For instance, the 1 year period has influenced how much we are able to investigate before filing a complaint and whether we are able to pursue informal negotiations before filing. These are two key steps that can benefit someone who has suffered discrimination. More investigation can strengthen the complaint by fleshing out the facts, and negotiations can secure a faster remedy for the problem with an employer or institution that may become intransigent once a formal complaint is filed. In at least two recent incidents, the 1 year period, the 1 year period was the decisive factor in the ACLU DC's decision to decline to provide representation to the potential client at all. We simply didn't have enough time. In contrast, we regularly sue under statutes with longer limitations periods, such as the Maine federal statute for constitutional civil actions, 42 USC 1983, and do not encounter the time pressure nearly as often or to the same degree. Consequently, we can obtain better results for our clients in these cases. Second, the DCHRA's limitations period is out of step with most jurisdictions' civil rights laws. Last year, the ACLU student chapter at Harvard Law School conducted a comprehensive review of state statutes of limitations for discrimination claims. The survey found that the one-year statute of limitations made DC civil rights law stricter than over 2/3 of all states. Specifically, 36 states were found to have periods longer than 1 year for discrimination cases, including many that were 2 or 3 years and even a handful that were 5 or 6. DC law was stingier in this regard, not just compared to states that have often led the way on civil rights, states like California, Illinois, Massachusetts, New York, New Jersey, and Washington State. It was also stingier than many other states, including Arkansas, Kentucky, Florida, Georgia, Oklahoma, Texas, Utah, and West Virginia, each of which had at least one anti-discrimination statute allowing at least 2 years to bring a claim. DC law was stingier than both of its neighboring jurisdictions, Maryland and Virginia, each of which allows 2 or 3 years to bring discrimination claims. So the council should adopt a 3-year statute of limitations for all discrimination claims. This is the default statute of limitations for civil cases in DC where a limitation period is not otherwise specifically prescribed. It is also the period used in DC for constitutional claims and many claims of federal civil rights violations under federal statutes. We urge the council to extend the DC HRA's limitations period. Statutes that protect our fundamental civil rights and liberties are only as powerful as they are enforceable. If people who have suffered discrimination are shut out of court because the doors close on them too fast, then wrongs are not righted, discriminatory practices are left to persist, and our district is the less fair for it. I look forward to your questions.
Thank you. We'll now hear from Jonathan Booth.
Thank you very much, Chair Nadeau. Members of the committee, I am very pleased to testify on behalf of the Metropolitan Washington Employment Lawyers Association, an organization of attorneys who advocate for employees and for employee rights. I join in enthusiastically in the testimony of the 3 previous witnesses. The need for longer statute of limitations is apparent. I have remarks in my written testimony on it, as well as the need to make sure that our inadvertently narrow definition of sex harassment, which really didn't matter a whole lot until Congress passed the Ending Forced Arbitration in Sexual Assault and Sex Harassment cases, that really didn't matter, but now it does, and it should capture the true legal definition of sex harassment so that those cases are not forced into arbitration, which is a terribly unfair and unjust method of adjudication. I focus now on Bill 25-30319, which Mawila enthusiastically supports. One of the biggest flaws in the Human Rights Act, and I've got much lengthier testimony that's written. I'm going to try to use my 5 minutes quickly. So one of the significant flaws is the election of remedies feature of the DC Human Rights Act, which after the Office of Human Rights makes a finding of whether somebody has a claim of discrimination or not, which is just a preliminary finding and not adjudicatory, it relegates those claims purely to the administrative process. And in fact, for people who have a finding of no cause, they lose their rights under the Human Rights Act entirely. And individuals who have a claim of probable cause are relegated to the administrative process, which has a lot of flaws itself. Under jurisdictions throughout the country and in neighboring jurisdictions, there is no such election of remedies. People can go to court after they get a finding of cause or no cause. And in the private sector, in the EEOC, all claims go to court after a finding, can go to court after a finding, whether or not it's probable cause. But I want to bring up the parallel of Bill 25-319 to the federal sector that is administered by the EEOC. The 2 million employees in the federal government have a right to file EEOC complaints, to go to a hearing before an administrative judge at the EEOC, and to have a decision issued by that judge and to have a right to appeal to the broader EEOC, they can withdraw their claims at any time during that process and after a full adjudication of their rights in order to take their claims to court, because it improves civil rights. It improves the enforcement of civil rights for all individuals, which is the core purpose of the Human Rights Act. And I point this out and focus on this because I read the Office of Human Rights' testimony that indicated, made the contention that OHR is not like the EEOC. It is. EEOC adjudicates claims of federal employees on a much larger scale than does the Commission on Human Rights. And those employees, importantly, have the right to go to court. Rather than lose those rights, District of Columbia employees should have a right to go to court at any time. Many will remain in the administrative process. There are advantages for that. Many attorneys prefer the administrative process. That's fine, but they should have the option, as do employees across the United States. And 0319 would correct those flaws. It will correct two other important flaws as well. There is no reason at all for the mayor's order that governs administrative claims of DC government employees to omit an award of compensatory damages or attorney's fees. Bill 250319 would correct that flaw, which is quite obvious. It would also empower the Commission on Human Rights to award punitive damages, something available to private sector employees in court, but not before the Commission on Human Rights. And that's an important tool to deter and to prevent discrimination, which is the very purpose of the act. We are very pleased that OHR is supporting reform of the election of remedies, but it clearly does not go long enough. It should be allowed at all times.
Thank you so much. Our next witness is Micah Salb.
I have a cold, so I'll try to avoid rude noises. Chairman Nadeau, in October of 2015, DCPS math teacher Tamu Turner was assaulted by a student. By November, the panic attacks and severe agoraphobia that the attack triggered had so worsened that she had to take time off from work. Her physician diagnosed her with PTSD, but cleared her return to work in a non-classroom setting. Unfortunately, it quickly became clear that DCPS would not provide an accommodation, so Ms. Turner sought help from the Office of Human Rights. Nearly 2 years passed before OHR issued its determination. It found that there was no probable cause to believe that DCPS had failed to reasonably accommodate. OHR's determination was illogical and barely reflected the actual facts of the case. 3 years later, the DC Court of Appeals would reverse, soundly rejecting OHR's determination. A prudent person, seeing the poor analysis and plain misstatement of the facts in the no cause finding, would have quickly left OHR for the Superior Court, where she would be more likely to get an outcome based on facts and reason. But Ms. Turner couldn't do that. She was forced to continue litigating at OHR based on current law. This is fundamentally unfair and serves no purpose other than to restrict access to justice. Of all the cases that OHR has docketed over the past 5 years, it's mediated about half. Half of those mediated cases have settled, albeit for a scant $15,750 per complainant on average. If an OHR case does not settle, it progresses to the cause-no cause process. Of the approximately 1,250 cases which did not settle over the past 5 years, only 58 were certified to the Commission. The other 1,206 cases were presumably dismissed via findings of no cause. Thus, a complainant who turns to OHR for help has but one route to any remedy at all: mediation, yielding paltry results, or else they have less than a 5% chance of getting a hearing on the merits. If they are advised by an experienced plaintiff's employment lawyer, they would probably leave OHR and file suit in Superior Court. But a victim of discrimination shouldn't need a lawyer's advice to avoid this trap. Passage of this act would fix this defect in the DC HRA so that complainants won't have their cases extinguished forever if OHR issues a no-cause finding, as it virtually always does. I urge you to support this act. Thank you, and I welcome your questions.
Thank you for your testimony, and I hope you feel better soon.
Thank you.
Next, we'll hear from Laura Brown.
Hi, good afternoon. On behalf of First Shift Justice Project, I thank you for the work of the committee and your sponsorship of B25-0319, the Fairness in Human Rights Administration Amendment Act of 2023. First Shift represents and advises DC workers who suffer from workplace discrimination based on pregnancy, family responsibilities, and domestic violence, all of which are protected characteristics under DC's Human Rights Act. We have a vested interest in improving the processes at the DC Office of Human Rights for workers in low-wage jobs who have suffered devastating job loss due to the discriminatory actions of their employers. The proposed legislation will eliminate the election of remedies provision in the law. This provision routinely trips up low-wage workers who are more likely to be pursuing their cases on a pro se basis without the guidance of a lawyer. When workers initiate the OHR process, most think that if they don't get a remedy, they'll be able to file in court to have a judge consider their case. Charging parties who submit claims at OHR are not informed that they are making an election not to go to court and waiving their rights if they see the OHR process through to the end. In fact, a litigant who receives a no probable cause determination does lose their opportunity to go to court. Per the OHR process, they do not have the right to de novo review. There is no opportunity to introduce new evidence. And while this is difficult for someone, even with legal counsel, it is untenable for someone, usually a low-wage worker, who is proceeding on an unrepresented pro se basis. Before I worked at First Shift, I directed the Workers' Rights Clinic, which is now coordinated by the Washington Lawyers Committee. One of the most unfortunate circumstances I encountered was to have workers coming into our clinic with no probable cause determinations from OHR, hoping to find a lawyer who could help them file in court. After hearing clients' stories, we frequently identified other evidence that might have been helpful in supporting their claim at OHR, but which they had not produced. Pro se litigants at OHR may offer what they think is relevant evidence, but since they don't understand the legal standards, they don't know. We told them it was too late to introduce any additional evidence. Moreover, we also had to advise them it was unlikely that any lawyer would represent them going forward because of the impossibility of introducing new evidence. This is not justice. Low-wage workers and others who are not able to secure representation for their discrimination claims are often encouraged to file their claims at the Office of Human Rights as a pro se friendly forum. But OHR's process is not pro se friendly if litigants unknowingly waive their rights by filing there. At its extreme, this results in a two-tiered system of justice in which the discrimination claims of low-wage workers who are less likely to be represented are relegated to an administrative agency while workers with means can proceed in court. There are a few other issues that First Shift would like to comment on with respect to this legislation. First, First Shift supports empowering the Human Rights Commission to award punitive damages in private sector discrimination cases. The threat of punitive damages is an important deterrent for bad actor employers in the district. Second, we are concerned by proposed language by the Office of Human Rights to this legislation that reference its supposed inherent prosecutorial discretion to dismiss claims. As an agency charged with eradicating discrimination in DC, the only basis for dismissing a claim should be a lack of jurisdiction or lack of probable cause. We oppose the addition of any language to this statute that suggests otherwise. And finally, we request that the committee add language to this bill that would expand the statute of limitations for discrimination claims from 1 to 3 years. This issue is particularly relevant to workers with claims of pregnancy discrimination, a significant percentage of first shift's caseload. Pregnant workers are often not aware that their employer's actions are illegal until well after an adverse employment action occurs. And by the time they figure it out, their circumstances may prevent them from filing timely claims. Pregnant workers are managing their health at the same time they are in the midst of a significant transition in their family, which becomes a crisis when they suffer job loss. And even when they understand their termination was illegal, they're practically prevented from taking legal action because they're simply unable to prioritize it in light of the need to provide food and shelter for their families, recover from childbirth, care for a newborn, and seek other employment. Expanding the statute of limitations would allow more workers to pursue their legitimate legal claims. Thank you.
Thank you very much for your testimony. We'll now hear from Stephen Pershing.
Good afternoon. It's not morning anymore. I'm Steve Pershing. I'm of counsel to the plaintiff's side employment firm in town called Calajarvi, Chusey, Newman, and Fitch. I used to be a DOJ civil rights lawyer. I've lived in the district a long time, always preferring it to our neighbor jurisdictions. And this statute is one of the many reasons. I'm active in Moelia. You've already heard from Jonathan Puth, who has spoken for Moelia, and I'd like to speak on behalf of our law firm, which brings all sorts of cases on behalf of employees, including proceedings in the administrative forum provided by the DCHRA. The statute's justly recognized as one of the most important pieces of legislation this council has ever enacted. Today, we have the opportunity to make a good statute even better in several important ways. These have been percolating in our bar and on council for years, as you've already heard. I and my firm wish to express our strong support for these amendments, our full concurrence with every remark already offered by our preceding witnesses. But I thought I would sign up to testify to give a case story about the election of remedies requirement. For the past 3 years, I've represented a modest fellow now in his 70s who was a property manager at a DC apartment complex. He blew the whistle on his employer's refusal to rent to housing voucher beneficiaries. Now, a refusal to rent on that basis is a source of income discrimination in housing, of course, violates the HRA and the apartment complex retaliated by having my client fired. OHR investigated the case. It was filed timely. They took 1.5 years to come up with a finding. They found probable cause to believe that prohibited retaliation had occurred. And of course, that finding is pretty rare among all the cases that OHR investigates. And it means there's a strong basis in evidence showing a civil rights violation. And you'd think that a violation like that, a finding like that, would lead directly to a remedy, but the employer moved for reconsideration, claiming it had new evidence, but in fact, offering none, just treading old ground that they'd already decided in the finding letter. So here's where the problem arises. OHR has to investigate the case it thought was off its plate all over again. And unlike in court, at OHR, that motion to reconsider goes all the way to the back of the line. It took them 1.5 years in the first place in this case, but we've been waiting since September 2020, the date of the probable cause finding. The employer moved for reconsideration in October. We responded in November. The investigator politely informed us she needed no further information. Don't send us anything else. And as far as we know, the case has not moved in the 3 years since. So under the proposed amendments in this bill, my client and an untold number like him wouldn't be stuck in OHR like that literally for years. They could have filed in court long before now. He's waited far too long for a remedy in his case. He's elderly, doesn't have steady work since his firing, et cetera. And meanwhile, the employer all this time has basically enjoyed complete impunity for what happened. We don't even know if the prohibited discrimination that my client blew the whistle on has ceased. So I'd have to say this is exactly what, justice delayed is justice denied looks like. The irony is that OHR already did its work in this case once. It fulfilled its statutory function to investigate a charge, reach a finding at minimal cost to the complainant and to the responding party. That's the purpose of OHR. What we have now is an employer throwing a procedural monkey wrench into the proceeding that will delay it indefinitely. Employers know they can do this. They make a regular practice of it. And that prevents enforcement of the HRA for as long as the delay lasts. We don't think really relaxation of the election of remedies requirement will impair the functioning of OHR at all or reduce at all its value to our community. As I've tried to suggest, it's about cost in large part. On the contrary, it will ease burdens on OHR while still allowing them to perform their valuable work. It will strengthen the statute. It will allow it to do what this council has always intended for it to do, remedy and deter civil rights violations in the district. Thank you so much for the chance to testify before you today, Chairman Nadeau.
Very much for your testimony. And now we'll hear from our final witness on this panel, Frank Silberstein.
Madam Chair, first I wanted to thank you for allowing me to speak before the committee today. My name is Frank Silberstein, and I am the National EEO Fair Practice Coordinator for the Washington Metropolitan Area for my government union, AFGE. In my role, I represent the EO concerns and interests for over 4,000 District of Columbia employees, as well as all federal employees in the DC area that AFG represents. When first elected into this position about 9 years ago, I went to OHR on behalf of AFG and requested EO training so that AFG legal staff, as well as all union EO representatives, could get updated training in the EO process. OHR immediately responded by sending out OHR attorney Alexis Taylor, who came down to AFG headquarters, where she provided an excellent EO and FMLA slide presentation for AFGE. As time passed, the laws had changed, district mayoral administration had changed, and AFG's own legal staff and local representatives and local presidents had also changed. So I again went down to OHR for a much needed legal training update. OHR again responded with a union designed slideshow presentation by OHR attorney Rashawn Caulfield at 8 OHR's offices. The union felt both trainings allowed a lively interactive exchange between OHR attorneys and the union as well. And this improved AFG's understanding remarkably. We felt it was extremely helpful when the OHR attorney requested questions be submitted ahead of the training so as to allow them an opportunity to provide more informative answers, and he also took questions on the spot. And they also took questions on the spot. Both OHR attorneys did not leave until every question was addressed. Unfortunately, since then, although I have requested AFG tailored trainings repeatedly, OHR has not provided such trainings. This is quite concerning given that OHR staff literally post on their website that they offer community outreach trainings to eradicate discrimination. We therefore urge the council to support legislation that requires such critically needed training at least annually, if not semi-annually. As many EO representatives and the complainants regularly work interactively with AFG attorneys, it is critical to have a union training that incorporates both AFG legal staff and local union staff as well interacting in such trainings. In past trainings, we also noted disturbing patterns as well as severe individual violations, and the OHR attorney took notice at those trainings. Since then, we have noticed many locals have reported continuing violations. The federal agencies that I also work with are required by the Federal Labor Relations Authority and sometimes even ordered by the EO Commission to bargain over agency EO policies. And bargaining over EO policies is one more reason why we need to have a union-tailored EO training. Finally, in years past, EO Commission Associate Director Dexter Brooks himself actually prepared critical EO trainings for AFG each time AFG requested them. Obviously, we expect the same standards for DC. For district and government employees to assert that they have more protected EO categories than federal employees, isn't it pointless to have such protections if they refuse to train the exclusive representatives for thousands of DC workers? Thank you for your time, and I have provided more detail and references in the testimony I submitted. If there are any questions, I'd be happy to answer them.
Thank you so much. Okay, so I do have some questions for this panel. Starting with our in-person witness. Thank you for bringing this issue to light, Ms. Green. Can you elaborate on how this is affecting the rights of DC residents?
Absolutely. So one of the ways that this is affecting folks, and I actually I have experienced this in terms of one of our clients. If someone hypothetically has been sexually harassed in the workplace under federal law, namely through hostile sexual harassment. So in a case where someone has been, as Dahe mentioned in her testimony, has been experiencing a supervisor making hostile comments about this person's sex. That under federal law is sexual harassment, but under DC, that is sex harassment. And so it's still illegal in DC, but it's not sexual harassment. And that distinction between sex and sexual harassment is important because of this Ending Forced Arbitration Act. So in that case, this person has a DCHRA claim for sex harassment and a Title VII claim for sexual harassment. And that Title VII claim can escape from the arbitration clause under this new Ending Forced Arbitration Act. But the DCHRA claim, I mean, I'll get into whether or not that is arguably possible because the Ending Forced Arbitration Act does permit all claims related to the underlying facts to be included. But it's possible that this person could have different statutes of limitations implications. So if they want to come forward on day 301, that's just outside of the Title VII statute of limitations, but it's still inside the current 1-year DCHRA statute of limitations, they would be trapped. They would have to do the arbitration. They would not be able to escape under the Ending Forced Arbitration Act because their claims would be bound by this arbitration clause that they had been forced to sign earlier in their employment. And that's one meaningful way where this person who otherwise, again, under federal law, should be able to proceed with their claims in court, but they're going to be restricted to arbitration. And that's just under the SOL. But there are other implications, as I mentioned earlier, with respect to DCHRA's lower standard for totality of the circumstances compared to Title VII's higher severe pervasive standard. That also has meaningful implications. But just in terms of can they escape from the clause, they can't even get out if they're outside of the Title VII statute of limitations.
Very helpful. Thank you. And what's been your experience litigating this in court? Has a DC court ruled on this?
Which part of it are you asking about?
Oh, sorry. Well, which part do you want? Oh, when the two laws are paired. Yeah, when you see that conflict.
So because the Ending Forced Arbitration Act is so new, I'm not actually aware of a case yet, but if any of my colleagues on the call are aware of one, I'd love for them to chime in. Applying that, I think that the language of the Ending Forced Arbitration Act should permit a claimant who is within the statute of limitations for both DCHRA and Title VII to bring both in court under the Ending Forced Arbitration Act and therefore escape both. But again, that statute of limitations difference creates meaningful implications because you'd have to be under 300 days in order to get them both. And
Okay.
again, I don't know of a court that has actually said that, but I would argue that the Ending Forced Arbitration Act should permit that.
If anybody else wants to chime in, feel free. Okay. Anything else you'd like to add?
No, thank you for the opportunity.
Okay. Mr. Michaelman, could you talk a little more about the ACLU survey conducted by Harvard Law on the SOL of other states? And do you know how states come up with how long a statute of limitations should be?
Thank you, Madam Chair. This survey was conducted by the student chapter in mid-2022 at my request, and it was reviewed by my staff. So this was, we've checked this. I don't know how each state selects its period of limitations. I should note that many states have multiple laws. So unlike the DCHRA, which is a single law covering many types of discrimination with mainly one procedure, there's different states may have, here's our employment law, and then at a different time, here's our fair housing law, here's our public accommodations law, et cetera. And so the nature of the survey was such that the students and then our staff checking it had to look into a number of different provisions. We also accounted for exhaustion deadlines. So we did not count as a 2-year statute of limitations a provision that required the complaining person first to exhaust, let's say within 90 days, and then to sue in court for 2 years. We were just looking at provisions that did actually allow 2 years to bring the complaint either to an agency or to court. So that's how we counted it. And then, because states structure themselves differently, it's sort of hard to generalize beyond that. But in each of the states, I mentioned the 36, there was at least one statute, and in many of them, most of them, multiple, that allowed 2 years or more, unlike DC.
Thank you so much. I think these questions can be for Mr. Puth and Mr. Saab. In your experience as attorneys, what are the pros of allowing litigants to withdraw at any time during the administrative process?
Well, it provides flexibility. It provides, as Mr. Pershing, gave the dramatic example of being tripped up in the administrative process. We're often confronted with clients coming to us and saying, "Well, I have a finding of probable cause." Not often, but it happens. I have a probable cause finding from OHR, and we know from experience and the experience of many of our colleagues that oftentimes that means that an individual does not have as robust an opportunity for full discovery, may not have as much opportunity to have claims promptly heard. There are attorneys who prefer the administrative process, but in our experience, court is a much more effective and efficient way of getting claims litigated, and particularly Superior Court. If somebody has a cause finding of any kind, and especially a no probable cause finding, they would have to abandon their rights to go forward under the Human Rights Act and look to other laws, such as federal law. That means they're in federal court. That means they're not able to use the Human Rights Act, which they may not have clear rights under federal law. And so it really undercuts in so many ways the ability to I think the most important thing that Mr. Pershing had alluded to is that employers are just looking to kick the can down the road. They're looking to gum up the works. They have more resources. They've got all the information and regarding the employment decisions at issue. So that means that it often takes the process of court litigation to really be able to get to the bottom of it. And by being tied up and tied to the administrative process, complainants lose the opportunity to put a little pressure back on the employer. And you know, when it comes time to get to a hearing or to a trial or otherwise, it's more often than not, those employers are ready to finally pay up if they get that far. But in the meantime, they'll work to gum up the works. So unless an employee has the opportunity to withdraw and move to another forum, they're really lacking in a key tool to just get the thing done and resolved and decided and move on with their lives and with ours.
Madam Chairman, I'd like to add to what Mr. Booth said. First, by talking a little bit about the fact that there are clear value. There's clear value coming from OHR. There are plenty of cases where OHR serves a really important purpose. A litigant, a potential litigant who can't afford a lawyer or can't find pro bono counsel may well be well served at OHR. A case where we're just not sure what the facts are or whether there's liability. Perhaps there's a real explanation that's legitimate. OHR can do some preliminary investigation. The employer generally is required to cooperate. And so you can get some information. There have been a number of times that I've seen where OHR early investigation provides some proof that the employer wasn't acting improperly. So it can properly extinguish claims. So there are, well, I guess I would also add that there are times that a litigant, a plaintiff, an employee is not sure whether they want to go to court or not, whether they want to have a full-blown hearing or not. And so they would go to OHR for some, again, preliminary process. But part of the fundamental unfairness of the inability, the inflexibility, the fact that you're stuck at OHR once a cause finding is issued, is that a cause finding is not the result of the adversarial process, which is the hallmark of American justice. It is an agency conclusion based on typically incomplete or at least limited process. And it's a determination as theoretically as to whether there is cause to believe that discrimination occurred or not. The fact that OHR determines that there is no cause to believe discrimination occurred in virtually every case. I think 56 cases over the last 5 years went to hearing. Now, some of them were settled. But it's just inconceivable that such numbers reflect truly when a case has cause to believe discrimination occurred or doesn't. So there's that defect, right? Litigants need to have the ability to leave the OHR process for a just outcome, but also to level the playing field even within OHR. Because if the employer knows that the employee can leave the OHR process, it gives greater possibility to reaching a settlement, because they know that the employee has some power Employees are completely powerless in the current arrangement, which is why the results in mediation are so abysmal. Thank you.
Thank you. What other jurisdictions have this practice?
I don't know that.
I do believe there are other jurisdictions that have an election of remedies. New York, which has a 3-year statute of limitations to go to court, does have a pure election of remedies. So practitioners don't file with the state agents. And is the anecdotal information I've received. But again, they've got 3 years to go to court. Anybody can go to the EEOC as well. I want to stress there are great advantages to the OHR and to the EEOC because it does give an opportunity for us to learn whether our client's case is strong or not, to value it properly, to seek to resolve it, or to seek to go to court if the other side doesn't want to resolve it reasonably. We have not done a comprehensive survey in MWELA, however, of other states that have pure elections of remedies. I can tell you that New York is one.
Does the EEOC allow it?
The EEOC never prevents a complainant from going to court. In the private sector, individuals go, they have a chance for investigation, for conciliation, hopefully to resolve their claims. Then they get a finding of probable cause or no probable cause, and they can go to court. And to add to the point that it's a non-adversarial, non-adjudicated finding, as is the OHR's, whether somebody comes to us with a no probable cause finding from the EEOC is really inconsequential to our evaluation of the claim. It just comes with part of the practice. They don't often issue cause findings. But the most important thing is for federal employees. Federal employees can file an EEOC complaint, have the complaint investigated, have opportunities for conciliation, file a request for hearing with an administrative judge, which is very much like an administrative law judge at the Commission on Human Rights, where they get discovery, where they get a full hearing, where they get a decision, where they can appeal a decision to the EEOC. And at any time in that process, before the EEOC or immediately following the final decision, they can file in court. They are never prevented from going to court. And that's for the 2 million plus federal employees out there. There are thousands and thousands of hearings pending right now, nearly 10,000 hearings pending right now before administrative judges in the EEOC for federal government employees. Those employees forever retain the rights to withdraw their claims and go to court. They don't forever. At the end of the proceedings, they'll have 90 days to do so. But they never lose the right to go to court because that's a more effective way of vindicating civil rights. We as attorneys for employees are without the employer's decisional process information. We need to get that information in discovery. There's an asymmetry in information. There's also an asymmetry in resources. Employers generally are able to afford, good attorneys and to be able to try and keep the information from us in many ways as to what actually happened. And so the need for options is optimal to be able to vindicate civil rights. It's not an easy thing to do. People say, well, how do you prove discrimination? Well, you work really hard and you dig and you dig and you dig. And the only reason we're doing this is because we're people who, we're bleeding hearts and we're, committed to civil rights. And it's really hard work. But if you take away that option to go to court, which the Human Rights Act does, it really cripples the ability to enforce a statute as important as the Human Rights Act. And it's done so for years. And this is not an issue that is shiny and sexy. And it's been, we've been working to try to get this for reform for a long time. It's time to get it done. Maybe the shininess and sexiness makes it a little more difficult to draw attention to it, but it's really a huge flaw in the Human Rights Act. And you'll see today that, I'm sorry for going on, but you don't see opposition here. The only opposition that I'm aware of that you've received, and I read the testimony, was from the Office of Human Rights. And they agree in the reform generally that it's not at the finding that an election should be made, that everybody should be able to go to court who has received a no probable cause finding. But for people who are heading to the commission, they do want to retain that feature. And their basic argument is that the EEOC is different than OHR, because OHR has the commission that adjudicates and decides claims at hearing. And it would make them irrelevant if complainants were able to pull their claims or even go to court after a decision. But that's how it works for the 2 million federal employees and for the EEOC adjudication of those claims. Exactly how it works. The EEOC is not different. They are the same for a much larger group of administrative judges, a much larger apparatus, and for a much larger number of complaints currently adhering.
Madam Chairwoman, I'd like to add 2 small notes. First, the concern that OHR would become irrelevant if they don't do hearings, I think, is mitigated somewhat by the fact that there are many litigants who prefer the more casual approach of an OHR or a commission hearing. They're more accessible. They're cheaper. They are at least theoretically faster, at least in some ways, maybe not to get there, but once you're there. And I think oftentimes the judges are quite approachable. So there is a benefit, which means that they won't become completely irrelevant. But I also want to make a comment. Maybe it's a little bit more dry than the issues of justice that Mr. Booth was discussing, but as it relates to comparing DC with other jurisdictions like New York. New York makes you make that election of remedies on day one. You file your complaint either in the New York system or in the federal system, and then you are essentially stuck. Now, that's more extreme, but on the other hand, it avoids a pernicious problem with the DC system, which is that people don't realize that they will be stuck. I think Ms. Brown discussed this earlier. People believe that they'll have flexibility. And so because they're not required to make that very clear election of remedies on day one, they start going down a path which ultimately traps them.
Thank you. What about the argument that if a litigant were to withdraw from OHR in order to file in another venue, their case may be barred based on the legal doctrine of res judicata, known as claim preclusion? Is that a valid concern here?
If I may, Your Honor, that's not a valid concern at all, because you, as the counsel, is passing a law to say the person can go to court. That means it is not by definition res judicata. And in fact, there's a provision, an explicit provision in the law that says a court may consider, but is not bound by any finding or fact or determination or record in the administrative process. So there is no concern.
Fantastic. Thank you. A couple more for you to Do you think it would be a waste of agency resources to allow an individual to withdraw and go to Superior Court after discovery has been made?
No, no. In fact, it is maybe depriving the agency of the sexy part of the hearing, right? They want to reserve that to themselves. But the fact is that the agency has the ability to deliver some very useful services to the residents of the District of Columbia. Discovery can be incredibly powerful, not only to determine if somebody has a case, but also to determine if they don't have a case. And so, no, it's not even remotely a waste.
I might add, Chairman Nadeau, that
Please.
one very likely reason why somebody might want to withdraw and go to court is the delay. My case is only one of who knows how many that have suffered these kinds of delays. And what they would be doing by withdrawing is, in effect, leaving that long queue that's already there at OHR. They're in effect going to be relieved of the overburden that they have now, rather than somehow recede into irrelevancy. They're still going to have a full caseload, is what I suspect. That's what we don't really understand about OHR's opposition. The truth is they're overburdened. I don't think that's likely to change. This bill would not change it. They would have to grow by fivefold, I suspect, to really make a dent. But the real issue, I think, for council to think about is the effect on settlement dynamics. If you have an indefinite delay, you can outweight the complaining party. That's what employers want. They want the person on the other side to give up. And the longer it goes on, the more likely that outcome is. Whereas if they know the person could pull the plug on the administrative process if the delay is too long and go to court, right away that has a pro-plaintiff impact on the settlement dynamic, or I should just say it reduces the considerable advantage that employers, particularly, but not only large employers, enjoy as the system is now.
I may, Your Honor, the law recognizes that the purpose of the administrative agency, whether it's OHR or EEOC, is to investigate and to conciliate claims. Those are the primary purposes of the law. And information, this discovery, which I've mentioned, there's an information asymmetry between employers and employees, but for both parties, for them to better understand the facts, the motivations, the demands, and the harm visited upon the complainant are all good things, because those attorneys can learn the value better or the risk on the side of the employer and come to an agreement. And employers almost invariably come to agreement. The number of cases filed in court that go to trial in employment cases is less than 3 or 4%. It's tiny. We had a case that settled last night on colleagues were heading to an EEOC administrative hearing today, and it settled last night. That's the way these things go, and they want to resolve it. So that discovery, that information is all extraordinarily helpful to both parties in the process in coming to that mutual understanding of what the facts and the harm are in the case and what the value of it is. It doesn't mean they'll agree, but it does get them closer to that. OHR is performing that service, which is their job. That's a good thing, not a bad thing. The only other thing I would add about whether this is going to help or hurt OHR, it's not going to change for the no probable cause people. It's going to give them a right to go to court. It's not going to take any more resources of the Office of Human Rights in order for those claims, in order to have that right to go to court. For the people who do get probable cause, they're heading to the commission process right now, and they're heading to the commission process after this bill passes, but some of them will leave and go to court. That's going to save money. That's going to save resources and put those resources into private hands and into the court system. So on balance, if we're looking at the overburdened, underfunded OHR. This is going to help them from a pure budget standpoint. I don't see how it hurts them in any way.
Thank you. One question for Mr. Silberstein.
Yes.
What was OHR's response when you asked them to restart the trainings on these issues?
I think I went down to OHR. It was before the pandemic, and it was in 2018, or 2019. And they told me they did not have the bandwidth.
And is this a training the union can receive elsewhere?
No, we do receive federal training through the commission, or we provide our own trainings to our own EO representatives. But we don't, as far as I know, we don't have such training elsewhere. Nobody's directed me from HR to get those trainings from an outside source.
What is your ask today? Are you asking the committee to legislate that OHR restore the trainings and provide them annually?
Annually would be sufficient, I believe, and for several reasons. Since the training that we had last time, the code has changed, and EO law has changed as well, and we have new staff, we have new attorneys. So yeah, annually would be good because there's updates. There's evolving EO law, and there's needs. We have new local presidents, new EO representatives as well. Yes.
Thank you. Anything else you'd like to say on the record?
Yeah, just one day. We've done it one shot, every year. We've also in these trainings, I'd like to say that we've reported patterns of violations in OHR, and they took us seriously, I believe, or at least they seem to. For instance, repeatedly, many locals, maybe most locals, from what I understand, were reporting that deadlines were not made that were required by EO counselors. And it's still going on. We found out there's been egregious violations. For instance, I know you've mentioned earlier in the day issues with sexual harassment. We've had a complainant, for instance, that had multiple witnesses, reported it with her union president and locals. In fact, including a manager representative, and yet she was not separated. The complainant was not separated from her alleged harasser, and he continued to threaten her and actually issued suspensions. And that's just unacceptable. And we've got to have an avenue where we can report and, have some sort of a contact with the OHR to prevent these things from going on repeatedly. And hopefully the trainings, and bargaining needs that we have will hopefully prevent a lot of these problems from going on. So I think that's all I have to say.
Thank you very much. Anything that others would like to say before we conclude this panel? Okay. Well, thank you, everybody, for your participation. We'll now be joined by our government witness, Director Kine of the Office of Human Rights, who will speak to Bill 25-319, Fairness and Human Rights Administration Amendment Act. And before you get comfy, you could raise your right hand. Whoever you like, and we'll have you all sworn. Absolutely. Excellent. Do you swear or affirm under penalty of perjury that the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Fantastic. When you're ready, you may begin.
Good afternoon, Chairperson Nadeau, committee members, and staff of the Committee on Public Works and Operations. I'm Nin Kine, Director of the DC Office of Human Rights. Thank you so much for the opportunity to testify today on Bill 25-0319, the Fairness and Human Rights Administration Amendment Act of 2023. Which proposes major revisions to the administrative process and authorizes additional remedies in claims brought under the DC Human Rights Act. These revisions, the majority of which are procedural in nature, can be summarized in the following 4 main ways. First, it would permit private and public sector complainants to withdraw at any time during the administrative process, even after a final trial-like evidentiary hearing. Second, following the withdrawal, the bill would require OHR to provide all complainants with a notice of right to sue in court. Third, these actions would then allow all complainants, public and private sector, to file a de novo or new complaint in court. Finally, the bill seeks to authorize additional remedies in both public and private sector cases. In public sector, the bill would authorize attorney's fees and all forms of compensatory damages, and in private sector cases, it would add punitive damages. With this background today, I will try to provide insights from OHR's role as a neutral fact-finding agency and provide clarity to this, particularly the way in which our administrative process works in DC. Before I get too far in depth, though, I want to note that any changes made to the Human Rights Act will also impact other laws which follow the HRA for case processing and remedies. To fully understand the impact of the proposed changes, it's important to lay out the existing process. At present, to file claims under the HRA, individuals have a choice and may choose to either file in court or file a complaint with the Office of Human Rights. This is because the administrative process that exists is substantially similar to litigation in court. In other words, the administrative process is an alternative to going to court and in a way allows OHR and our courts in DC to share the overall workload. By comparison, this is not the same when it comes to the Federal Equal Opportunities Commission, known as the EEOC. Specifically, Title VII of the Civil Rights Act of 1964, the federal law prohibiting employment discrimination in private sector, has an exhaustion requirement where complainants must first exhaust administrative remedies by first filing with the EEOC before they can go to court. This is not true in DC. In DC, complainants can go to court or come to OHR. They do not have to come to OHR first, like the EEOC. And after the EEOC's administrative process, a complainant can obtain what's called a right to sue letter. And this is because the EEOC process in this particular context only consists of the probable cause determination investigation. There is no evidentiary hearing held in private sector cases before the EEOC. And thus, they are not considered what we call contested cases. And so then individuals do retain their right to file a civil action in court. In DC, if a complainant chooses to come to OHR instead of filing in court, our administrative process does include a final trial-like hearing, and thus our process is divided into 2 parts. The first part, similar to the EEOC, it's true, includes investigation of the claims to determine whether or not there is probable cause to believe discrimination occurred. The second part, however, is different. It consists of getting the case to a final evidentiary hearing, much like a trial in court. A case is certified for a hearing if OHR finds probable cause. Throughout both parts of the process, unlike in courts though, OHR's staff facilitates multiple opportunities for settlement discussions. In addition, in private sector cases, OHR's attorneys prosecute the cases in the public interest by presenting the case at the hearing. Moreover, as compared to courts, our administrative process is free. There is no filing fee. And the government takes the lead in collecting the evidence from witnesses, like documentary evidence from both parties. And this is an incredible cost-saving benefit for complainants. I will now briefly outline the first part of our process. After an initial complaint is filed with OHR, we review the complaint and, if necessary, conduct an intake interview. If the complaint is formally docketed as a charge of discrimination, OHR provides a free mediation session to provide the parties an opportunity for early resolution. If mediation doesn't result in resolution, OHR conducts a very thorough investigation and produces a comprehensive letter of determination, which we call an LOD, detailing whether or not the record OHR obtained supports a probable cause to believe a violation of the DCHRA has occurred. At present, complainants may withdraw their complaint at any point prior to the issuance of the letter of determination. And if they wish, they can file a new de novo complaint in court. If OHR finds no probable cause, a complainant may seek reconsideration from OHR or seek judicial review by filing what's called a petition for review with the DC Superior Court. But they may not file a de novo complaint in court. If OHR finds probable cause, the case proceeds to conciliation and then to the second part of the process, the formal evidentiary hearing. If after the hearing, a complainant is dissatisfied with the final decision, they may appeal the decision to the DC Court of Appeals. Once a case is set for an evidentiary hearing, the case proceeds much like in court, where our assigned administrative law judge issues a scheduling order to allow the parties to conduct full discovery, meaning there is an exchange of evidence from both parties, including witness names, documentary evidence, and essentially prepare for the final hearing, just like a trial in court. At the hearing, the parties, like in court, may present documentary and witness evidence in support or against allegations asserted in the complaint. And we offer settlement conferences at this juncture as well. In private sector cases, OHR attorneys enter their appearance to pursue the public interest. While OHR does not represent complainants, we are authorized in our pursuit of public interest to seek make-whole remedies for victims of discrimination. And I'm so proud to share that OHR has fully staffed this work since 2018, and it has been a very successful endeavor. For instance, in FY23, just last year, private settlements between the parties after certification to the commission, meaning this is after conciliation during the process leading up to the trial-like hearing, we were able to obtain over $436,000 in private settlements. And OHR also entered into multiple years-long compliance agreements with respondents. In FY23, OHR actively monitored 13 of these voluntary compliance agreements where in the public interest, OHR is able to secure policy changes, require year-long trainings, and post notices, all of which OHR reviews for compliance each year for the life of the agreement. B250319 would significantly alter the current process by permitting complainants to withdraw their complaints during the administrative process at any time, including after that evidentiary hearing before an ALJ. This means an individual could withdraw and file a de novo or new complaint in court at 3 different points. 1, prior to OHR issuing a decision on probable cause. 2, after OHR issues its post-investigation letter of determination, regardless of whether or not we find probable cause. And 3, after the public evidentiary hearing before our ALJs. OHR doesn't oppose the ability to withdraw after the second juncture, but we do have some concerns about withdrawing after the final hearing. As I mentioned earlier, our administrative hearing is much like a trial in court in that it is a robust process consisting of full discovery, motions practice, full examination of witnesses during the hearing. It also is legally significant to note that our hearings are conducted in accordance with the DC Administrative Procedures Act, or the DC APA. As such, once a case has been heard, meaning a hearing has been held, it is considered a contested case under the DC APA, much like a case in court is reviewed as a contested case because it's been fully adjudicated. In private sector cases, one of the greatest differences between our hearings and trials in courts is that OHR leads the prosecution of these cases, providing pro se individuals with savings in both costs and time. Over the years, our chief ALJ has worked hard to develop detailed resources to assist pro se litigants in navigating this process. Upon the conclusion of the evidentiary, if there is a finding of discrimination, our ALJs, just like Article 3 court judges in Superior Court, can award the full set of available remedies like fines, restoration of benefits, actual damages, including back pay, and in private sector cases, as of now, compensatory damages and attorney's fees. Given the breadth of the court-like hearing process, the full availability of remedies, and the contested nature of our evidentiary hearings, OHR does not agree with the proposed revisions to allow a complainant to file in court de novo after the final administrative hearing. Doing so will undermine the principles of judicial economy and essentially render the entire administrative process somewhat moot. Again, OHR doesn't have an objection to withdrawing after the probable cause or no probable cause termination for that matter. But OHR recommends after this point, though, that complainants be required to elect to proceed whether to go with the administrative process for the evidentiary hearing or proceed with filing in court. For comparison, OHR has reviewed the post-hearing procedures in private sector cases at the EEOC and other similar agencies, and OHR has not yet found a jurisdiction where private sector cases can be filed in de novo after a final evidentiary hearing for contested cases. In sum, as I have detailed today, OHR is generally very supportive of the additional opportunity for complainants to withdraw and file in court, but we do highly recommend that there is a point at which complainants should choose which process they wish to proceed. OHR has submitted our proposed clarifications and additions to the committee. We look forward to continuing these discussions and working with the committee on providing fair access to justice without undermining our city's very limited resources. Before I conclude my testimony entirely, I want to add a brief note regarding B250351, the Sexual Harassment Investigation Integrity Amendment Act of 2023, since that was placed on the agenda today and it also seeks to amend the DCHRA. As noted earlier, we know that bill was intended to require the DC OIG to make a referral to an independent investigator regarding employer investigations of sexual harassment allegations against certain senior officials. But the relevant provisions currently reads as follows: investigations of a formal or informal complaint of harassment or other unlawful discriminatory practice to be referred to the Inspector General. And as noted earlier, the issue there, of course, is that the reference of the term harassment is without the qualifier sexual harassment, and because it says other unlawful discriminatory practice, which would refer to every applicable claims under the DCHRA. And so because this bill would amend the DCHRA and is designed to be codified in the same section as processing cases for government complaints, I fear there can be confusion about whether this referral for an employer investigation would be substituted for the legal process at OHR. I suggest that if the council decides to move forward with that legislation, that it be a standalone bill that does not amend the DCHRA to avoid any confusion regarding government's complainants' rights to bring their legal claims to OHR or the courts. Thank you for that. I know this was rather long, but it concludes my testimony, and I appreciate the chance and look forward to any questions you may have.
Thank you so much. Just regarding B25-319, have OHR's duties changed at all under the mayor's updated sexual harassment order?
I don't think it has changed significantly. It has changed in some sense in that we are more actively involved in the sexual harassment task force. But so I would say it's, additional, but not significant.
So in your testimony, you indicated the OIG referral for an employer investigation under the bill could be mistaken for or substituted in place of existing legal processes currently at OHR. Could you say more about how that would trigger that?
Sure. So I believe right now it intends on amending the DC Human Rights Act at Section 303. And subsection A and B of those sections refer to our rules in place for processing district government cases for EEO complaints, violations of the DCHRA. And so then the current law is seeking to house subsection C, create a new subsection C within Section 303 that talks about referral to the OIG. And so our fear, as the inspector also identified, is that that can be confused as a substitution and or a similar process, which of course, as we know, they're two different processes with two different legal significance and impact.
I understand your recommendation is to make it a standalone bill rather than a mandatory bill to the Human Rights Act. However, if we did want to keep it under the Human Rights Act, is there another section you would recommend?
We could certainly look into that and get back to you.
Okay, thank you very much.
Happy to do that.
Thanks. The committee is considering whether the definition of sexual harassment in the DC Human Rights Act should be expanded. And we heard testimony that recent expansions of the sexual harassment definition in the DCHRA may have inadvertently narrowed the definition from that generally understood in federal law. The issue here is what constitutes sexual harassment under the DC definition will determine who is covered under the recent federal law. Is OHR aware of this recent change in its current effect?
Thank you. So we find that our current definition with the recent council's amendment is quite broad, as a matter of fact, in looking at harassment and particularly sex or sexual harassment. That said, we've not had a chance to closely look at the ending Forced Arbitration Act, the federal provision that Rachel Green, our earlier public witness, was referring to. And so we are actually planning on hopefully contacting Rachel Green and also studying that act to see how it fully impacts our current provision.
Great. She's still in the room, so that
We'll
should
talk.
be easy enough. Okay.
And we'll get back to you, Chairperson, on that.
Okay, fantastic. Thank you. The committee is currently considering expanding the statute of limitations for discrimination claims from 1 year to 3 years. This is based on testimony we heard earlier this year during performance oversight that the statute of limitations in DC is basically too short at a practical level. We also heard testimony today supporting this change. Why is DC statute of limitations only 1 year? Is that arbitrary or did it have some significance?
I'm not sure I would have any reliable knowledge to share on why.
Do you oppose that provision?
I would say I would just ask the committee to consider a few points from a government perspective in terms of operations and challenges. So extending the statute of limitation, I assume now you're considering extending for all claims, not just sexual harassment. Is that correct, Chairperson?
Yes.
Okay. Extending any kind of statute limitation obviously would mean that we may get additional cases at OHR, which may require additional resources. So that's always a forefront concern for government operations. But substantively, though, I would also caution in considering the length of the extension because the longer the time is extended to file a case, the case can, or the evidence, the required evidence to, as the attorneys spoke about earlier, the required evidence to prove or establish the claim can become stale, meaning that you can lose evidentiary pieces like documents, very critical documents like policies that, let's say in a sexual harassment, might govern what a process was and whether or not an employer followed that process in the policy. That's a very important part of the legal analysis in determining a violation. And or even more important is witnesses. If witnesses retire, if witnesses are, unfortunately, if they're not with us anymore, or if they move, they've gone to a different country, it does make for a very difficult and challenging problem for not just OHR, but for the courts and frankly, all of the litigants to obtain this evidence in order to prove the case. And I would note here, hearing all of the comments from our public witnesses that we are open to discussing how we can strengthen the Human Rights Act, but I think there are some other issues at play that we can address as well that I may not have sufficient time to address right now, but happy to engage in that conversation.
Okay. And All right, so some of the other changes in the legislation I want to turn to. So you testified that any time before a letter of determination is issued, complainants may withdraw their complaint and file a new complaint in court. Can you explain to me why litigants can only withdraw up to that point?
I think that that is rooted in statutory language. Is that right, General Counsel?
That's correct. It's a statutory requirement.
Mhm.
In the DCHRA.
I do want to better understand why the agency is opposed to allowing litigants to withdraw at any time and refile cases in Superior Court. So according to your testimony, you said an individual can withdraw and file a complaint in Superior Court prior to OHR issuing a decision on probable cause, correct?
Correct.
Okay. You also said if OHR finds probable cause, the case proceeds to the evidentiary hearing. Is that right?
Correct.
But before the final evidentiary hearing takes place, the litigants are in a process of discovery, meaning exchanging evidence and preparing for the final hearing. Is that right?
Exactly.
Okay. And all this is done before an administrative law judge makes any adjudicated findings that are determined as final, right?
Correct.
So if the point of discovery is to uncover information from both sides and a final judgment has not yet been made, why shouldn't we allow individuals to withdraw if OHR has only made preliminary non-adjudicated findings?
Oh, I think, thank you for bringing that up. Our thought is that complainants should be able to withdraw after our probable cause finding and even throughout the process, but just not if there has been a hearing held where the final issues have been adjudicated and evidence has been assessed and evaluated and a finding has been made by the ALJ, if that makes sense. I'm happy to clarify.
Does it make sense to you? Oh, okay. So, but they can't withdraw in court after the probable cause has been determined?
They can't now, but
Yeah.
what we're saying is that we agree that they should be able to do that after a probable cause finding.
Okay.
What we're saying,
Got it.
and it may be slightly different from what we've said, in previous conversations on this issue, but what we're saying is that we would like to work with the committee on finding a timeline between OHR issuing that probable cause determination. Yes, either no cause or probable cause, doesn't matter. After that point, and to the point of the final hearing, or again, if you want to think of it as a final trial, we want to say, let's find a juncture at which we allow the complainants to choose whether they want to go or they want to stay. Because that was, that will serve everybody's interests in being able to go to court, but also not have the government waste its resources. And so I think in speaking about government resources, it's very important to remember that unlike in many other jurisdictions, in private sector cases, right, OHR's attorneys are in the cases. So not only do we work on investigating the cases to the probable cause point, not only do we have mediators and conciliators working to resolve the cases at the front and middle of the cases, we also then have attorneys that are actively, at least one or two attorneys that are actively engaged because the statute requires that our attorneys are present in every single private sector case that proceeds to the commission hearing, to the trial.
Okay.
So if we have all of those attorneys dedicated to every case that we have going to the hearings and all that just to sort of get it retried in court, it is a complete waste of our resources. But if we can identify a point at which, I get it, after probable cause, whether cause or no cause, complainants would like an opportunity to go to court, we have no objections to that. But we do believe that it would be prudent and would serve the interests of everyone involved to sort of a middle ground, if you will, to identify a point between our probable cause finding and the final trial.
And you're saying that you want that because of the resources? Is that the only reason?
I mean, the resources, and I think that, and General Counsel Gobler, you can go ahead and add in if you have thoughts, but I think resources and again, the issue of time, right? If we have cases going to court to trial after that entire process, there's additional time tacked on it will make it much harder to then retry the case. And before I pass
Harder
on
for
to
the complainant? Harder for who to retry the case?
harder for everyone.
Okay.
Because, the fact finder, whether that's a jury in trial or a bench trial where a judge is sitting to make a fact finding, it would make it difficult to actually obtain that evidence that you need the more time that's on the books. So I very much agree with our colleagues. I practice in private plaintiff side employment law for 8 years before coming to OHR.
Right.
And so I get that time is not on the complainant side. The longer it takes, the worse it gets. And we want to work towards eliminating that time so that cases are much faster. And extending the process isn't a way to eliminate time that's added on to a case. If you want to think of it as a book collecting dust, you're just going to collect more dust as the time goes on. Whereas I think the focus should be on trying to make sure that our processes are tight and that they're working and that they're impactful.
Do you think that would have been your opinion when you were in private practice too? Or is that something that you've come to as a government official?
Which part?
That the elapsed time creates a problem, because it seems like they were saying that's not their problem. That's not the issue that they see.
I don't know. I mean, your lens, they're different depending on where you've been. And I think from a neutral fact-finding agency standpoint, for sure, I do know, and from having experience in litigating these cases, even at OHR, when we go through that trial process before the commission, we know that the longer it takes, the harder it is to find witnesses to come and testify. And without witnesses or critical documentary evidence that can get destroyed, there's also a host of, I'm sure if you talk to some of the attorneys in the community will tell you the issue of spoliation, right? You can lose deletion, accidental deletion of evidence, critical evidence, the more time that goes on in a case.
How long do people have to wait right now between probable cause and their hearing at OHR?
So we strive for 15 months. And I will get back to you on what our percentage is, because we do have that figure. I just don't have it on top of my head right now.
How is that compared to if they went to court?
Much better. Courts, it can languish anywhere from 3 to 10 years.
Okay. Sorry, I could see you were trying to jump in.
No, thank you. Thank you. I just wanted to add real quick that in addition to the time and administrative resources, there was a lot of testimony by our public witnesses, especially from Moella and Mr. Puth, about the EEOC federal sector process, and where in that sector, there is an ability that after an adjudicative hearing, you can go de novo to court. What I'd like to have just a nuance here, though, is that for here, what this bill is going to do would be not just for cases against a government employer. It would be against for all employers. So your mom and pop, your small business owner has gone through in a full adjudicative hearing before an administrative law judge with full discovery, motions practice, depositions, gotten through evidentiary hearing. I just had one that was 9 days. And if there is now a finding that they did not discriminate, there's no finality for that small business owner at all, because that complainant could say, I got a bad ruling, I'm going to go now completely de novo to court. And I think that that consideration is very different than what happens in the federal sector EEOC, where it's the federal government. And here, having to expand that to allow that against any single employer just doesn't provide any finality with our process either, regardless of kind of how long it would take or anything like that. As a neutral body, we have to think certainly, and we provide resources for complainants, but we do need to think about the other part of the parties here and provide some type of guidance for them as well as finality. And so I urge you to see that that is a huge distinction from what the federal sector process allows for de novo review in court, where it does not allow that, including for the EEOC, private sector. There's no similar case. There's not any type of adjudicative hearing before the EEOC that then a private sector complainant could say, oh, I want to go to court now. All they're given to is a right to sue for either probable cause or not probable cause. And as Director Kine said, we certainly don't have concerns with that aspect.
And Chairperson Nadeau, if I may, I want to chime in a little bit more on your question about, do I think this differently if I were in private sector plaintiff side attorney? And I want to add that I think it's significant to note again that our general counsel's attorneys, we have separate attorneys that prosecute these cases, which means we're on the plaintiff side of bringing these cases. So we want these cases to succeed. And this is why I made the point to tell you that in 2018, we had funding to actually fulfill that mandate, which I think is an amazing mandate that has had an impact on respondents wanting to resolve our cases, because now OHR attorneys are prosecuting them. And so we're on the same page as them. We want to bring closure. We want to provide remedies to those that have been victims of discrimination. That is our ultimate goal. It's not to keep dragging the cases, and it's not to oppose, great provisions to strengthen the Human Rights Act. We're on the same side of them. We have the same problems that they do when we're trying to prosecute these cases before the commission.
And one of the points raised today was that withdrawal post-decision could actually lighten OHR's caseload. How do you contemplate that?
I think that's hard to contemplate. I don't know that it would lighten. I think maybe it would not add, maybe is a potential thought, but I don't know that it would lighten. And it certainly would require us to think a little bit more about, what that would entail. But I'm not sure that I would agree with that right now.
In your testimony, you mentioned that private settlements between the parties after certification to the commission amounted to approximately $436,550 in FY23. I don't have a comparative basis here, such as previous year's figures or data collected from other jurisdictions, but it seems low.
We're happy to provide that data. And also, I think it depends if you look at the number of cases.
Okay.
Right. So I can tell you that the number of pending cases for private sector in our commission is around anywhere from 10 to 20. So we're looking at the number of cases that are resolved. So I'll get that number for you, though, Chairperson.
Okay.
I think that's an excellent point.
Yeah.
And we'll get some comparison data for you as well.
Great.
And I also urge you to think about the non-monetary piece with our VCA, which are so important, because we do have large impactful, I will say, respondents without naming names, who we have gotten to agree to making huge policy changes that impacts hundreds of workers in their employment in DC. And that's, it's hard to measure and quantify, but it is an impact that we have because our attorneys are in the cases, prosecuting these cases and working to secure these policy changes in these cases when they resolve.
Thank you. So I'd like to think that changing the law to award punitive damages in private sector cases, especially in housing cases, would serve as a meaningful deterrent to breaking civil rights laws. The notion is that landlords should not have the ability to repeatedly flout the law and accumulate violations with impunity solely because they can afford legal representation to litigate such matters at their own pace. What are your thoughts on that? Do you agree, disagree?
We don't have any objections for that.
Okay.
Would certainly agree.
Even better. Okay. You stated in your testimony that changes made to the Human Rights Act will also impact other laws which follow the HRA for case processing and remedies. You list the DC FMLA, Fair Criminal Record Screening for Housing and Protecting Pregnant Workers Fairness Act. Can you discuss what effect the changes will have on each of these laws? So starting with family and medical leave.
Yeah, I will leave FMLA and PPWFA to my very able and I'm sure willing general counsel here. But I will just touch on the Fair Criminal Record Screening Act, both in housing and employment. As you may know, those are what we categorize as compliance statutes, meaning they either complied with the law not to inquire about criminal backgrounds or they didn't. And so we are in process of trying to work on improving the processing of those cases, not to follow the HRA so that it doesn't take so long for us to have to process these cases. And so if we were to extend and make changes in the process, that could also impact those cases that we're trying to, again, our goal is to shrink the timeline, not expand. And so that could have a dilatory impact on those kinds of cases. But I'll let the general counsel address DCFMLA and PPWFA.
Thanks.
For both DCFMLA and PPWFA, they are individual standalone acts. They're not incorporated into the HRA. Rather, what they do is incorporate various sections and refer to the HRA And for Director Kine mentioning it, we just want to make you aware that if you want to do that, just in order to be consistent among all three statutes that rely on the exact same, I would say, administrative process, that you will just need to make sure to add that language either to this bill, or you'd have to make a subsequent amendment to the PPWFA and the DCFMLA, just because, again, they're not incorporated into the DCFMLA. They're standalone statutes.
Got it.
And if I may just add, Chairperson Nadeau, that our overall recommendation to the council has been to ask to consider whether or not, when we legislate new laws, whether they should follow the HRA process. And so we're happy to have additional supplemental conversation about each of these laws, so that we are actually making case-by-case analysis as to its impact for each of the laws.
Great. Thank you. That concludes my questions. All right.
All right, thank you.
So thank you both very much for your testimony today. This will conclude our public hearing. For those who have not yet submitted written testimony, please do so by submitting it on the council's hearing management system. The record for this hearing will close at 5 p.m. on Wednesday, December 27th, 2023. The time is now 1:32 p.m. and this hearing is adjourned.